Okay, you're seeing my screen now?
Yes.
Yes.
Okay. I think I'm going to go to this screen, which is a little bit more operable. Okay, so we're going to get into definitions and basic terms that are described in California workers' compensation. There's two basic references that you should be familiar with for definitions of basic terms. One comes from the QME regulations, and I've provided that for you as one of your handout materials. The second is California Code of Regulations 9793, and have a link here. I can just show you that document. It's on the website. This is 9793. So this contains a lot of definitions that you're going to need to be familiar with. So let's go over a couple of these from these particular references. Let's start first with the QME regulations. This is QME regulations. The very first regulation talks about definitions. Kind of makes sense, huh? So let's just pick out a couple of these definitions. We're not going to go through every single one of them, of course. But let's talk here about AME, first of all. AME. You've heard of this term. AME stands for Agreed Medical Evaluator. You'll hope that soon in your career, you'll be selected as an agreed medical evaluator. It's quite a high honor to have the parties agree that you will be the evaluator on any particular case. So the agreed medical evaluator is a physician selected by agreement between the parties. The parties include the claims administrator, or if none, the employer. Claims administrator and employer are sometimes synonymous terms. And a represented employee means represented by an attorney. To resolve disputed medical issues referred by the parties in a workers' compensation proceeding. So there's actually a mouthful in this definition. And this definition reminds us that the purpose of our evaluations is to resolve disputed medical issues. Our job is to resolve disputed medical issues. Now, in the workers' compensation system, there's a whole world of disputes. Not all of the disputes are medical disputes, but when there are medical disputes, then we're called in to resolve those disputes. And the agreed medical evaluator is an evaluating doctor, not necessarily a QME, doesn't have to be a QME to be an AME. But the AME is quite a prestigious distinction because it signifies that your reputation has elevated high enough that the parties know you, trust you, and believe that you have the ability to bring the case to a successful resolution. So that's AME. Comprehensive medical legal evaluation. This is what you're going to be doing as a QME. These are medical evaluations performed pursuant to Labor Code sections 4060, 4061, 62, 2.1, and 2.2. And we're going to go over each and every one of these in painstaking fashion. So you're going to know these inside and out, and you're going to learn how it is that these labor codes cause your phone to ring with a request for an evaluation. These are some of the labor codes that you need to know, not necessarily by number, but in concept. You need to know these in concept because these labor codes serve as great fodder for test questions. That's comprehensive medical legal evaluation. Continuing education programs. Continuing education program is a systematic learning experience, such as a course, seminar, or computer learning program, which serves to develop, maintain, or increase the knowledge of qualified medical evaluators. And you're all going to be required to complete ongoing continuing education in order to recertify your QME credential every 2 years. And you're part of a new group who, by the time you are required to recertify, the continuing education requirements are going to be moving from 12 hours to 16 hours. So you'll be part of the first group required to do 16 hours, which isn't a big deal. It's not a big deal, 8 hours a year, right? One Saturday per year. Can even be done home study. on the go, what have you. These can be done as distant learning programs. So I think that's a good thing that the requirement is going from 12 hours to 16 hours. The difference between 12 and 16 is 4 hours. And those 4 hours are very clearly defined in the new regulations. They're going to include 2 hours of anti-bias training, and they're going to include 2 hours in case law updates. So you'll be required to, at least for 2 hours every 2 years, to be current on what are the most important cases that are shaping the workers' compensation system. Let's talk about the DEU. The DEU is the Disability Evaluation Unit under the Administrative Director, responsible for the issuing of summary disability ratings. So you might think of the DEU as the end of the line. The DEU is the group at the end of the line that finally gets your report and is going to issue a disability rating to the injured worker, for which the claims administrator is then going to be obligated to compensate the injured worker. So the DEU, they require some certain things in your report. They require that your reports be clear, that they be accurate, that they be well explained, and that they be consistent, certainly with the AMA guides. So you'll be sending one of your envelopes. You'll be addressing one of your envelopes of your reports. One of the parties that will receive your envelopes is the Disability Evaluation Unit. Okay, so they are important players. We don't often get to rub elbows with these people. They work very hard in Oakland, and we don't hear a lot from them unless, for some reason, your report turns out to be not rateable. They can't use your report. And then you'll hear from them as they send you some information and ask you to shore up certain aspects of your report. We have follow-up comprehensive medical legal evaluation. We just talked about the comprehensive medical legal evaluation. The follow-up is a medical evaluation that's performed pursuant also to 4060, 4061, and those same labor codes that govern the requirement for a comprehensive medical evaluation. So same labor codes drive the follow-up medical legal evaluation. And the follow-up medical legal evaluation comprises one of about 4 basic cycles that you'll be involved with as a QME. We have the initial comprehensive medical legal evaluation. We have this one, the follow-up comprehensive medical legal evaluation. We have supplemental medical legal evaluations, and then we have medical legal testimony, which are depositions. So those are the 4 different types of activities that you'll be participating in as a qualified medical evaluator. And we'll talk a little bit more about each of those, including medical legal testimony. Panel QME. Panel QME is going to be you. You're going to be the panel QME in 100% of your cases that you get, unless you get some AME cases. Nearly 99% or 100% of all your evaluations are going to be as the panel QME. So the panel QME means you, the physician, who has obtained from a QME panel list that's provided by the medical director and who is selected under Labor Code Section 4062.1C. So this talks about the QME panel selection process. I'm going to share with you the QME panel selection process here in today's session. You need to understand the QME panel selection process because it's this process that gets your phone to ring. And if you can understand what's operative behind the scenes that causes your phone to ring, it'll many times give you great insight into what's actually going on with the case, what's driving the case, and what is the need for your evaluation. So 4062.1C and all of these labor codes that I'm pointing out to you in these definitions, these are the important ones that you need to highlight with your yellow highlighter and make sure that you have a good grasp of these particular labor codes. So it's 4062.1C that we rely on when we have an injured worker who is not represented by an attorney. This is the section of the law, 4062.1c, that describes how an unrepresented injured worker goes through the process. That's 4062.1c. Well, we have a different section of the law, which is 4062.2c. See, this is 0.1c. This is 0.2c. And you don't need to know these numbers, but you need to know the concept behind the number. It's 62.2c that governs the pathway that the represented injured worker obtains a QME panel. Okay, so they represented and unrepresented injured workers have different pathways to the QME panel. Okay, we'll go over that in great detail in today's session. Finally, the qualified medical evaluator, that's you. This is a physician licensed by the appropriate licensing body. So I'm a chiropractor. I'm licensed by the Board of Chiropractic Examiners. So a physician licensed by the appropriate licensing body and appointed by the administrative director at the DIR, Department of Industrial Relations, pursuant to Labor Code Section 139.2, which we were going to review here in about the next half hour. Provided, however, that acupuncturist QMEs, and I don't think we have an acupuncturist QME any in the audience, but it says that acupuncturist QMEs are QMEs with one exception, and that is that they shall not perform evaluations to determine disability. Okay, so I have one acupuncture QME as a client in my chiropractic management company. I have one acupuncture doctor. They don't get a lot of cases, and the reason that they don't get a lot of cases, which is unfortunate for acupuncturists, is because they can take an evaluation all the way to third base, but they can't bring that evaluation home to home base because they're not allowed by law to comment on permanent disability or permanent impairment. So if they're not able to comment on impairment or disability, then they're also not able to comment on the apportionment of the impairment or the disability. And so those are two major sections, key money driver sections of the report that an acupuncturist just by law is not able to comment upon. So an acupuncturist QME can take a report only to the stage of permanent and stationary. They can make determinations as to whether the examinee is permanent and stationary, but if the examinee is permanent and stationary and has a disability, they cannot comment on that. I don't know why that is. I don't know why that is. I don't know why that is, because acupuncturist doctors are very qualified to comment on disability, but by law, they're not allowed to comment on those things. Okay, so those are some definitions from the QME regulations. Let's take a look at some of the definitions according to CCR 9793. So I have that link here. Okay, so here's CCR 9793. Now, interesting, CCR 9793, that stands for California Code of Regulations. And whenever you hear the term regulations or QME regulations, you're talking about California Code of Regulations. CCR is the abbreviation. So you'll see that all the time. So here we are in CCR 9793. And you may or may not know this, but our fee schedule is described in CCR 9795. So here we are in just two regulations before our fee schedule. We're getting close to our fee schedule. So some of these definitions lead into the definitions that we deal with when we deal with our fee schedule. So first of all, we have a claim. What is a claim? A claim, an insurance claim, injury claim. A claim is a claim for compensation. So when injured workers file claims, they're seeking compensation. They file a claim to obtain compensation, to obtain benefits under the California Workers' Compensation. And the claim is evidenced either by filing a claim form pursuant to Section 5401 of the Labor Code, which talks about the necessity of providing notice in writing of an injury. An injured worker is required by law, the law is 5401, to provide a written notice of an injury. But there are some exceptions to that requirement for written notice. Those exceptions are described in 5400 and 5402 of the Labor Code. So 5401 creates a strict and rigid requirement of a written notice, but 5402 and 5400 soften that written requirement, whereby basically anything can constitute notice of an injury. And you're going to get injured workers that when you ask them, did you report the injury? Did you file a claim form? And they're going to tell you things like, well, I had my brother-in-law call the boss. Or they're going to say things like, I put a Post-it note on the computer of my supervisor, on my computer, my supervisor's monitor. And they're going to talk about all of these things as to how they reported the injury, which are allowed and which constitute notice and evidence of an injury under these particular labor codes. So almost anything can constitute a claim, and you're going to see that as a QME. You're going to get some cases where you go, oh my God, I can't really believe this is a claim. And those claims are allowed, these spurious claims are allowed under these two sections of the labor code. A contested claim, so there's two types of claims. There's claims that are accepted claims, and there are claims on the other end of the spectrum that are the contested claims or the disputed claims, or many times they come to us as denied claims, okay? So this is a contested claim. This is where you start to get the aha moment about what these things really mean. I'll explain to you how you're going to encounter these in your practice as a QME. So a contested claim is any of the following. For example, it's where the claims administrator has rejected liability. The claims administrator gets out the big denied stamp, puts a denied stamp on the claim, and you're going to get denied claims. You're going to get them. They're going to comprise fully 50% of your caseload as a QME, because many claims that are filed are denied claims. They become denied claims, and they require a medical determination from you to resolve medical disputes. Okay, so this is going to form the bulk of your business right here, the denied claim. A contested claim is also where the claims administrator has failed to accept liability, and the claim has become presumptively compensable. So this goes back to Labor Code Section 5402, which is the weak reported injury, the weakly reported injury, WEAK, the weakly or poorly reported injury, where it's presumptively compensable, but the claims administrator says, nah, you know what? I'm not ready to accept liability. I want to investigate this thing. I want to think about it. I want to interview some people. So this is sort of like not a full denial, but perhaps a delay of acceptance of liability. Many times they require a medical determination, like, hey, is this person hurt or not? They send them to you to find out, hey, is this person hurt or not? We're getting a claim. Is this person hurt or not? Okay, and this is where you come in. Or, for example, where the claims administrator has in fact accepted liability for the claim, but there's a disputed medical fact that still exists. Like what? Like what? Let's say, for example, a person files a claim for a lower back injury from lifting bags of concrete on the loading dock at Home Depot. And the claims administrator, they can buy that, they can understand that, they can accept that. But at the same time, the injured worker is claiming injury for digestive disorder due to taking too many Advils for the back pain. Okay, you can see how these cases can compound. And the claims administrator says, well, we'll accept the back injury. We'll accept the back injury, but we dispute the fact that there's an injury to the gastrointestinal system. And they send this person to a gastroenterology specialist to resolve the disputed medical fact. Okay, very, very interesting This is gonna be the source, your source of business and revenue is the contested claim. And contested claims have an exact and specific handling. So when you get your first contested claim, you give me a call and we'll go over how to handle it. Okay. Okay, we talked about the comprehensive medical legal evaluation. Let's go to a disputed medical fact. Disputed medical fact means an issue in dispute, including an objection under 4062 of the Labor Code to a medical determination made by a treating physician. Okay, let's just wrap our head around this for a minute. We have an injured worker who's receiving treatment under workers' compensation, and the primary treating physician on that case writes a report, and that report contains a fact that becomes disputed. That report contains something that the claims administrator objects to, or contains something that the patient or the examinee, the injured worker, objects to, or it contains something that any of the parties object to. So interesting. So the primary treating physician's report serves as a great source of objections, to which brings us a huge volume of cases. Like what? Like what? Like, let's say the primary treating physician is tired of this injured worker and tells the injured worker, you can go back to full work duty, you're off disability, you're fine, you can go back to full work duty. And the employee objects, says, no, I'm not fine. I'm not ready to go back to work. Or the primary treating physician says in his or her report that this injured worker needs a sleep study and a right shoulder MRI. And the claims administrator says, no, I object to that. I'm not providing a sleep study. I'm not providing a shoulder MRI. This has to do with a lower back case. And the point is that there's this whole cornucopia, this whole universe of objections that can arise from the primary treating physician's report. Here they give a couple of examples, like the employee's medical condition. Sometimes the primary treating physician says the employee is not permanent and stationary. Claims administrator goes, not permanent and stationary. Guy's been off work for a year, get chiropractic, acupuncture, pain injections. How come he's not permanent and stationary yet? And they object to the report of the primary treating physician. The cause of the employee's medical condition is something that serves as great source of objection. It's not the employee's medical condition that's the source of the objection. It's not the condition. It's the cause of the condition. So an example would be, we're not disputing that this person has loss of hearing. The dispute isn't over the loss of hearing. The dispute is over what's the cause of this loss of hearing? Why am I, as the claims administrator, liable for this loss of hearing? What's the cause? Okay? And then just on and on and on. This section number 3 has to deal with, and I'll explain this. Let's read this just for your understanding. For injuries that occurred before January 1st, 2013, concerning a dispute over utilization review decision, if the decision is communicated to the requesting physician on or before June 30, 2013. So do you think that these are important dates that you should know? They are. I'll tell you why. These are disputes that deal with the treatment of the employee's medical condition. So what you need to know about this is that before 2013, we as qualified medical evaluators had medical treatment disputes in our wheelhouse of issues that we resolved as qualified medical evaluators. Stated differently, we used to resolve medical treatment disputes as qualified medical evaluators. Primary treating physician says, I want this injured worker to have a right shoulder MRI. The claims administrator objects to that, sends that person to us to determine, is a right shoulder MRI necessary or is it not necessary? We used to resolve medical treatment disputes, and that was a great source of business. We lost that source of business in 2013 because now, after June 30, 2013, medical treatment disputes are not resolved by the qualified medical evaluator. They're resolved by a different department, a new department called Independent Medical Review, IMR. So I describe that as points of historic interest for you because you're rarely going to encounter dates of injury before 2013, but also because so that you're aware of these dates and how they relate to independent medical review, because you can be certain that these are some of the dates that you'll have to understand when you see these questions on the QME competency exam that talks about a firefighter who suffered an injury in 2011, and you're thinking 2011, that was before IMR. Okay, that's how you'll have to apply this knowledge to the competency exam. Okay, moving on. Let's talk about medical legal expense. These are your costs. Your costs are medical legal expense. These are any costs or expenses incurred by or on behalf of any party or parties, incurred by the administrative director, incurred by the appeals board, or any of these parties for what? For various services. For what? For example, x-rays, laboratory fees, diagnostic tests, medical reports like your reports, your medical reports, like your medical testimony in deposition, our interpreter's fees, or any fees that are associated with proving or disproving a contested claim. The cost of medical evaluations, tests, interpreters is not a medical legal expense unless it's incidental to the production of a comprehensive report, follow-up report, supplemental report, or deposition testimony. And all of the following conditions exist, and you should read this and be familiar with this. This talks about medical legal expenses. You're going to be intimately associated and emotional about your medical legal expenses. Medical legal testimony means expert testimony provided by a physician at a deposition, and you're going to get depositions. You're going to get depositions. I estimate that approximately 40% of your cases will involve a deposition. We get deposition requests here in this office daily for requests for deposition. So it's expert testimony provided by a physician at a deposition or at the appeals board, at an appeals board hearing, which I've never been to. In 29 years as a QME, I've never been to a WCAB hearing. Any disputes or any information that the parties need can always be obtained from us either through a supplemental report or at a deposition. And I want you to look forward to your first, your 50th, and your 100th deposition, because depositions are a normal part of this business that we're involved in. And the purpose of a deposition is simply for all the parties to come together as a team. It's kind of like a football huddle where everybody gets together and decides, how can we move this case from second base to third base, or from third base to home base? In other words, we're stuck, and we need to get together to figure out how we can bring this case to a resolution. And because you're a player in that process, you will be called to deposition. Many times new QMEs are apprehensive about depositions. So when you get your first deposition, give me a call and I'll calm you down about deposition, because depositions are nothing to get worked up about. In fact, depositions are tremendous tremendous learning experiences that will accelerate your development. And also they pay pretty well. So I want you to look forward to depositions. Okay, finally, we have the supplemental medical legal report. I said that's one of your third cycles of action that you'll be involved in as a QME. Let's close up by talking about record review, because this is new. This is new. You don't know it, but this is new. So record review means the review by a physician, It doesn't say by the secretary in the back office, okay? It says by a physician of documents sent to the physician in connection with a medical legal evaluation or a request for a report, like a supplemental report, for example. Now, here's new language. This is new language. Let me show you this. It says here that this new language was operative 4/1/21. So this is the result of the new fee schedule, okay? The documents may consist of medical records, legal transcripts, medical test results, and/or other relevant documents for, like what? Like, how about deposition transcripts? How about job descriptions? Okay. How about, I don't know, anything that's relevant. It has to be relevant. It has to be relevant medically. For purposes of record review, a page is defined as an 8.5 by 11 single-sided document. So a double-sided document is 2 pages. It consists of a chart or paper, whether in physical or electronic form. And you're probably going to want to get all of your documents in electronic form, because when they come in physical form, you're just going to be turning them into electronic form by scanning them and using them in electronic form. And there's many, many benefits to having your documents in electronic format. So if you can get them in electronic format to begin with, it saves you a couple of cycles of action in doing that conversion yourself. Multiple condensed pages or documents displayed on a single page shall be charged as separate pages. Okay, like sometimes we get deposition transcripts that are divided into 4. There's 4 pages on a single page. That single page constitutes 4 pages for purposes of this definition here. Any documents sent to the physician for record review must be accompanied by a declaration that the provider of the documents has complied with these provisions of the Labor Code, and then the declaration must also contain an attestation as to the total page count of the documents provided. So you get this big stack of medical records at your front door, and it looks big. And you think, there's probably 2,000 pages of records in there, and your mind does the math on what you're going to get for that. But you open it up, and lo and behold, there's no attestation to the page count. So what should you do? Well, what you should do is you should not review those records. What you should do is you should get on the phone and have your secretary demand an attestation immediately, because without the attestation, you cannot review those medical records. Well, you can review them. You can do whatever you want, but you can't bill for them. Okay, you need the attestation to bill for them. Okay, now if you want to ignore those documents, you can ignore those documents if there's no attestation. It's like you never received them if there's no attestation. Okay, a physician may not bill for review of records that are not provided with this accompanied required declaration from the document provider. And I remember when this went down at the fee schedule committee meetings, it was such a big deal, this review of records, because we wanted to be paid for our time and our expertise in reviewing medical records. And so there was this back and forth about what constitutes a record and how much we should be paid for records. Is it $2 a page? Is it $5 a page? We finally settled in on $3 a page. But only when the records are attested, only when the page count is attested to by the party who sent them to you. Okay, you can't attest to the page count. Your attestation means nothing. It's the party that sends them to you is telling you how much they're willing to pay you for. Okay, if it's not accurate, you might have to go back and get a new attestation, and that happens. You get an attestation that says 100 pages and you open it up and it's 200 pages. You go, no, no, you're not going to get away with this. And you go back and you get an accurate attestation. Any documents or records that are sent to the physician without the required declaration and attestation shall not be considered available. What does that mean? That means I never got them. I didn't get them. They're not available to me. If you want me to review them, you have to send the attestation. It's in the law. It's not that you're being a punk. It's in the law. Okay? So as we talk about our fee schedule, you might get a case where there's, 199 pages of records, right below the page count threshold for which we can bill extra. It's 200 pages is the threshold. You might get a case where 199 pages, no attestation. Guess what? I never got them. Shall not be considered available to the physician or received by the physician. It's in the law for purposes of any duty regarding record and report writing. So very, very interesting, these definitions. They explain a lot. Before we move on, any questions on definitions? Review of records, medical legal testimony, any questions or comments on any of that? Okay. Okay, so then let's continue. Let's continue with some definitions and some sort of foundational concepts. Let's talk about the concepts and definitions of impairment versus disability and review what some of these references like the 2016 Physician's Guide and Labor Code Section 4600 have to say about these particular concepts. Okay, so here is some definitions from the AMA guides. And these are important words to understand because we deal with these every day. Impairment, disability, are they the same? Are they different? Sometimes, these words roll off of our tongues, but we don't use them properly. But they sound good, but we're not using them properly as these terms are defined in California workers' compensation. So according to the AMA guides on page 2, the definition of impairment is a loss of use, or a derangement of any body part, organ system, or organ function. So this is what we as qualified medical evaluators are going to be doing. We're going to be describing what is the examinee's loss of use, loss of function, or derangement of any body part, system, organ, or function. This is the medical determination. This is why we're called in, is to provide the impairment or the impairment rating. Now, the same source, the AMA guides talk about disability. Disability is a little bit different. Disability is defined as an alteration of an individual's capacity to meet personal, social, or occupational demands because of an impairment, Okay, so we're starting to see the interchanging of these two definitions. So that raises the concept, can a person have a disability? Or can a person not have a disability, but simultaneously have an impairment? Kind of an interesting concept. And you're going to have examinees who you determine have an impairment, but that impairment is not causing them any disability, okay? Particularly disability for their occupational demands, okay? So imagine a piano player that has a bad lower back. They have an impairment of the lower back, but that impairment of the lower back is not causing any alteration of their ability to meet, for example, their occupational demands. Very interesting. The 2016 Physician's Guide defines disability as a condition that interferes with the ability to work. So this is where we start to get now specific with California workers' compensation. Okay, the AMA guides is not involved with workers' compensation in the state of California, right? It's not a California specific document, but the 2016 Physician's Guide, this is a California specific document. One moment. Someone joining us now. Okay, so according to the 2016 Physicians Guide, disability is when a condition interferes with the ability to work or causes lost time from work. So this is where we get into the concept of compensable time off of work. Okay, so if we have an injured worker and they have a condition that takes them out of work, we say that then they are disabled. They might be temporarily totally disabled. They might be temporarily partially disabled, but it's when their condition takes them out of work. Now, if an injured worker has an injury, but it doesn't take them out of work, in other words, there's no lost time from work, particularly compensable time from work, then that condition does not constitute a disability. Very interesting. So disability is defined as lost time from work. An injured worker is disabled when they have lost time from work. Okay, many injured workers work with pain. They work with conditions. We all work with conditions, right? But it's when that condition causes lost time from work, especially lost income, which is compensable time from work. That's when we say that they have a disability. And disability is rated, if the examinee becomes permanent and stationary and they have a permanent disability is rated under Labor Code Section 4660. Okay, so let's talk about 4660. Let me pull up Labor Code Section 4660, or do I have that reference here? Yeah, let me pull up Labor Code 4660. By the way, a good reference for you, what is it, 4660? No, 4600, I'm sorry. Good reference for you for gaining access to all of these labor codes is this California Legislative Law webpage, Legal Info Legislature. You can just do a search here for every code. We used to have to go to a big book. Now we can just do it right here. Oh. Okay, let's go to 4660. Okay, so here's how permanent disabilities are rated in the state of California. So it says and this takes place down at the Disability Evaluation Unit, but you're involved with this. It says that in determining the percentages of permanent disability, okay, how much disabled is this person? You've heard people say, I was 60% disabled. Okay, this is where those percentages come from. Account is taken of three things. Three things go into the formulation of a permanent disability rating. Number one, account shall be taken of the nature of the physical injury or disfigurement. That's number one. Account shall also be taken of the occupation of the injured worker. Was he a construction worker? Was she a piano player? Was she a dog walker? Was she a chef? What have you? There are various occupation classes out of books and tables that they have down at the Disability Evaluation Unit. So they assign an occupation to the injured employee based on charts and tables that they have of these so-called occupation classes. So that's two things. And then three, account shall be taken of his or her age at the time of the injury. Okay, younger workers qualify for higher disability ratings for the same physical injury or disfigurement. For the same physical injury or disfigurement, they qualify for higher impairment ratings than do older workers because they have longer to work. They have more years to work, okay? So they take that into account. All of those three things give consideration to an employee's diminished future earning capacity. Now, fascinating, this is fascinating. Of those three things, the nature of the physical injury or disfigurement, the occupation of the employee, the age of the employee, which of those three things are subject to dispute? Is the age of the employee something that can be disputed? Probably not within narrow ranges. Okay, within narrow ranges, the person has a date of birth, and so we can calculate the age. That's not something that's in dispute. Is the occupation something that can be disputed? Probably not. I mean, sometimes we hear about disputes regarding occupation class. Is she a class 502 or a class 504? Right? Okay, but that can be quickly established and agreed upon. It's the nature of the physical injury or disfigurement that's the greatest variable that determines the permanent disability rating. Isn't that interesting? That's where you come in as a qualified medical evaluator to tell us what is the nature of the physical injury or disfigurement. Okay. Now, the next section says, for purposes of this section, meaning for purposes of establishing the permanent disability rating, the nature of the physical injury or disfigurement shall incorporate the descriptions and measurements of the impairments and the corresponding percentages of impairments from the AMA guides. So this is where you come in. This is your role as the qualified medical evaluator. Your job is to tell us through the use of this tool, the AMA guides, to tell us what is the impairment percentage for this injury or disfigurement. This is where you come in as the expert medical evaluator. And it's at this point where disability and impairment intersect, okay? Your job is to tell us what is the impairment through the use of the AMA guides. The impairment rating that you provide is then adjusted for age, it's then adjusted for occupation, and it's converted through formulas down at the disability evaluation unit into a final disability rating. Isn't that interesting? Isn't that fascinating? So you're a key player in this whole process. You're the player in the area where the greatest opportunity for dispute is, and that is the description of the physical impairment and your description of the percentage of that permanent impairment. Very, very interesting. Any questions on that? Okay, so those are some basic definitions that you're going to deal with, and those are some sort of foundational concepts that govern the type of work that we do. Let's shift gears now, and we're about halfway to our first break, maybe a little bit more than halfway to our first break. I want to talk about some concepts about California workers' compensation that will help you understand how we got to where we are today. And you're coming in here in 2024, right on the cusp of some new regulations that further are hoping to improve the system. So the system is constantly evolving, it's constantly developing, and you're coming in at a good time. So let's go to the 2016 Physician's Guide and talk about some of the history of California workers' compensation here in the state of California. Go to the Physician's Guide. You all have this reference. And I want to go right to the beginning of the 2016 Physician's Guide and talk here about Chapter 1, the history of workers' compensation in the state of California. Okay? Now just pull out some of the key excerpts that are important for you. So let's talk about it. So if you can understand the history of the system, you understand basically what's going on with each of these cases that you're called on to evaluate. So by way of history, the workers' compensation systems were established in the early 20th century. Prior to that, employees injured on the job had to pursue a civil tort action against their employers to recover losses due to their injury. But because few injured workers could afford to hire a lawyer, and many were deterred by the fear of losing their job. And people will tell you all the time that they didn't file a claim because they were afraid of losing their job. This was not an option for most. Okay, even people legitimately injured on the job, they didn't have any option. Employees who went to court had the difficult task of proving that their injury was caused by the employer's negligence. Even if the employees could prove negligence, employers commonly avoided liability by claiming that the worker's own negligence had contributed to their injury, or that another employee's action had caused the injury, or that the employees were aware of the danger but had chosen to continue to work and therefore had assumed the risk. And so this created a situation where the employers held all the cards. And it was very, very difficult for legitimately injured employees to get any benefits, any medical treatment, any disability benefits. They could not get any benefits, and they couldn't afford to champion their own cause and rally for their own cause. Well, and then the workers' compensation system became developed, and the purpose of the workers' compensation system was created to pay for the medical treatment of work-related injuries or illnesses and provide temporary payment for lost wages and permanent disability payments that compensate for an injured employee's decreased ability to compete in the open labor market. And now this phrase, decreased ability to compete in the open labor market, has been changed since the publication of this this 2016 physicians guide. This has been changed to diminished future earning capacity. And I showed you that in Labor Code 4660. So when an injured worker has a permanent impairment or a permanent disability, that disability causes them a loss of future earning capacity. And they get now compensated for their quote unquote loss of future earning capacity. So the workers' compensation system provides, some very definite benefits. It provides medical treatment benefits. It provides temporary disability benefits while a person receives treatment and recovers from an injury. They have temporary payment for lost wages. That's called temporary disability benefits. There's permanent disability benefits if that injured worker is left permanently impaired or permanently disabled. And then there's also death benefits in death cases. So there are death cases. You'd be surprised how many death cases there are in the workers' compensation system. There's a lot of deaths that happen on the job. So the workers' compensation system became a compromise. It's a trade-off between employers and employees, and it has these following features. It has three components of this historic compromise. Number one, it's a no-fault system. No-fault system. So it doesn't matter who's at fault for causing the injury, whether the employer's at fault, whether the employee's at fault. You're going to sit with injured workers and they're going to tell you a story where the injury was their fault. They did something stupid. You'll hear this all the time. I was walking out to my car at the end of my shift and I stepped off the curb and my knee buckled. Okay. Whose fault is that? Okay. So doesn't matter because this is a no-fault system. The employer is required to pay benefits no matter who caused the injury, as long as the injury arose out of or occurred in the course of employment. And these are the key phrases that you heard about. AOE is arise out of, COE is occurred in the course of. Okay. Number two is that the workers' compensation benefits provide the only and exclusive remedy to the problem. Okay. The benefits are contained and constrained within the workers' compensation system. It says unless the employer is uninsured, so it's talking about insured employers here, the worker cannot pursue other forms of recovery from the employer. So they can't sue the employer for negligence, for example, because the workers' compensation benefits are the exclusive remedy for the problem. They're the exclusive and only remedy to the situation. Even if the employer was grossly negligent. Now, on the other hand, if a third party contributed to an injury or the death, as might occur with a work-related car accident, the third party may be sued, and you'll get these cases all the time as well. The most common one is this work-related accident where, a person was on the job, they were legitimately on the job, maybe driving between job sites, what have you, and they're involved in an auto accident. So that's what's called a tandem claim. There's the workers' compensation claim, and then there's a personal injury claim. And you should develop a sense, meaning a nose, a sense, S-C-E-N-T-S. You should develop a sense for these type of tandem claims, because rarely is a claim a singular claim. Many, many times, more the rule than the exception is you're going to have these tandem claims. And there's a variety of different types of tandem claims. There's a work claim along with a wrongful termination claim. There's a work injury claim along with a claim for workplace harassment, sexual harassment, or discrimination. All these things, these tandem claims. You should develop a scent for these tandem claims. It's in a tandem claim where the person is seeking also a third party type of settlement. Finally, under the workers' compensation system, there is an assured and a fixed benefit. So it's assured, you can count on it, but it's fixed. And they tell us that the workers' compensation system establishes defined benefits for all 4 of those types of benefits that we talked about: medical treatment, temporary disability, permanent disability, and death benefits. All of those benefits are very tightly defined, all of which must be paid for by the employer. Workers' compensation awards are typically far less than comparable negligence awards in a civil suit. For example, although the maximum workers' compensation death benefit may be far less than the possible award in civil wrongful death, a civil action may take years to resolve, while a death claim can be resolved in as little as a few months. And then additional recoveries are available for employees for an employer's serious and willful misconduct, and also for unlawful discrimination. You're going to get these claims all the time. I'm just telling you. Okay, so those are the 3 benefits you can expect to be, presented with a multiple choice list on your QME competency exam about the historic compromise and the 3 components of the historic compromise. Now, there are exceptions to the no-fault rule, okay? So it's not a free-for-all party for all parties where you can do whatever you want and get away with it. There are exceptions. For example, deliberately self-inflicted injuries are excluded from coverage. Do you think you might ever encounter an injured worker who deliberately self-inflicted an injury? Well, I read some studies recently due to higher deductibles on private healthcare insurance policies, higher deductibles, higher co-payments. It's many times cost prohibitive for persons to seek medical treatment under their private healthcare insurance due to the high cost of rising deductibles. So in circumstances like that, these types of persons find ways to be injured at work, okay? This is the deliberately self-inflicted injury while at the workplace. Okay, I fell out of the dumpster. I fell out of the car, off the curb. I got hit by a bag of ice in the freezer. You're going to hear these types of stories. And the claims administrator may deny those types of claims if they smell or sense that that injury may have been self-inflicted. For injuries that result from the serious and willful misconduct of the injured employee, benefits are reduced by half. This is part of the fixed benefit, reduced by half, unless the injury resulted in death or a permanent disability of 70% or more, which are rare. Rare to see somebody with a 70% or more disability. It's certainly rare for me as a chiropractor. The injury resulted from failure of the employer to comply with the law or safety and health regulations, in which case the benefits may be increased. They can be increased by as much as half. And then these issues about whether or not there was serious and willful misconduct or whether there was gross negligence are resolved by the ultimate authority, which is the Workers' Compensation Appeals Board. Okay, so the Workers' Compensation Appeals Board is the ultimate authority on all issues related to workers' compensation. So I'm not sure if you've heard of that group, the WCAB. So the WCAB, you can think of them as the ultimate authority. Whenever disputes cannot be resolved by lower channels, ultimately those issues end up in front of the WCAB, and the WCAB resolves those issues. Okay, so that's a little bit about the historic compromise. So here's your three benefits again. The no fault, it's a no fault system. Workers' compensation benefits provide the exclusive remedy to the problem, and those benefits provide an assured and a fixed benefit. Okay, now something that you need to be aware of, and you've probably already heard about this, and it has to deal with the philosophy of the workers' compensation system. The philosophy of workers' compensation is described in Labor Code Section 3202, which is known as the liberal construction philosophy. So let me bring this up so you can see the actual language of it. So here's Labor Code Section 3202. It says, and this is so interesting. It says this division and Division 5. So what this means is that this section of the law, 3202, comes out of a section of the workers' compensation laws known as Division 4. So this is talking, when it says this division, it's talking about Division 4 of all of the workers' compensation laws. And you can trace those back by these headings here. Go all, here's Division 4 right here. Yeah, it says here Division 4. So we're in Division 4. So Division 4 begins with Labor Code Section 3200. Okay, this is 3202. So 3200 is two codes before this one. So it says this division, which is Division 4 and Division 5. Okay, so Division 4 begins with 3200. Division 5 begins with Section 6300. So how many codes are there in Division 4? It goes from 3200 to 6300. Hundreds and thousands of laws, okay, just in Division 4. And then it says Division 5, which terminates up at Labor Code 9000. So from 6300 up to 9000, all of those hundreds and thousands of laws. So now we have thousands and thousands of laws in California workers' compensation. All of them are governed by this particular statement. It says all of these laws shall be liberally construed by the courts with the purpose of extending their benefits for the protection of persons injured in the course of their employment. What does that mean? What does that mean to you? Can anyone offer some interpretation as to what this means? Anyone?
I mean, I would imagine it's in areas of grayness, it's to weigh in on the side of protecting workers because they're at risk of being, not fairly treated by the system.
That is correct. In any gray areas, any areas where there's doubt, uncertainty, the benefit of doubt is given to the injured worker. It's in the law. It's the law. So it says in this labor code, it says that it shall be liberally construed by the courts. What does that mean for us as qualified medical evaluators? It means that we also, because the QME, the labor codes that govern the QME process are in Divisions 4 and Divisions 5. So we also must have this liberal construction philosophy as qualified medical evaluators. And you can think of it this way. The workers' compensation system, the purpose of the workers' compensation system is to deliver benefits. It's a benefit delivery system. It's a delivery system for benefits for people who are injured in the course and arising out of and occurring in the course of their work. If there's any gray area as to whether the injury qualifies as a compensable injury, those gray areas are resolved, are liberally construed in favor of the injured worker. Now, that doesn't mean you bend over and you provide benefits for every single person that claims benefits. There's still some burdens of proof that apply. We'll talk about burdens of proof here in a couple minutes, but still, the overriding philosophy is that this system is here to protect persons who are injured in the course of their employment. And if there's any doubt, any uncertainty, any impasse, and we don't know which way to go or how to decide, it's like in baseball, the tie goes to the runner at first base. It's the rule and it's the law. So that's liberal construction. And I encourage you to, adopt this as your mentality when you go into each and every face-to-face evaluation, that you're there to see what you can do to help out the injured worker. When you can, if you can, you're there to liberally construe what they tell you for the purpose of protecting them and for the purpose of providing them benefits under workers' compensation. Very interesting. Okay, so that's liberal construction, and we talked about the California workers' compensation system and how it liberally construes all of its laws for the protection of persons injured at work. Let's now talk about Labor Code Section 3600, which tells us about the conditions. What conditions have to be present in order for a claim for industrial injury to be compensable? Okay, because many people get hurt at work, but in many circumstances, the conditions that require compensation for that injury are not present, and those persons do not qualify for benefits even though they are injured. So this is Labor Code Section 3600, and this is one of the sections of the law that has many, many subsections that you do need to be familiar with. And it's a fascinating section of the law. So let's go over this, and then we'll take our first break. This is Labor Code Section 3600. Have any of you come across this section in your studies? I hope there's some yeses. Anyone? Okay, so let's go over it. We're going to go over this word by word, and there's 10 sections of this law, and we're going to dissect these with a microscope. Okay, if you understand this, this is the source of so many test questions here. It says, liability for the compensation that's provided by this division, again, this is in Division 4, in lieu of any other liability whatsoever to any person, shall, without regard to negligence, we talked about that, it's a no-fault system. Liability shall exist against an employer for any injury sustained by his or her employees, as long as that injury arises out of and occurs in the course of, there's your AOE and COE, and for the death of any employee if the injury proximately causes death, in those cases where the following conditions concur. So here are the conditions. This is called the conditions of compensation liability. Here's the things that need to be present in order for compensation to be due. Number one, the employer and the employee are subject to the compensation provisions of this division. Basically, what that means is that the employee and the employer have an employment relationship. Okay? Do you think you'll get cases where the employer is contending that this person was not an employee either ever or at the time, or at the time the person was doing the activity they described, they were not acting in the course of their employment? So you're going to get this type of dispute all the time. Hey, that person wasn't even an employee. You'll get those kind of cases where at the time of the injury, the employee is performing service growing out of and incidental to his or her employment and is acting within the course of his or her employment. You're going to get these disputes all the time. The employer will dispute that, sure, the person's hurt, but the way that they got hurt was not in the course of providing service incidental to the employment, okay? Where the injury is proximately caused by the employment, either with or without negligence, okay? So these conditions need to be present. There need to be an employment relationship, and the injury needs to arise out of and occur in the course of employment, okay? So if we could, we would draw a dividing line here between number 3 and number 4, okay? And what we get into down here between number 4 and number 10, these are what are known as the affirmative defenses. The affirmative defenses. These are the defenses that either the employer or the claims administrator will raise in an effort to object to liability for the injury. These are known as the affirmative defenses. So let's go through these one at a time. And you'll get these. You'll get these defenses in the cover letters that you get. So the first of the affirmative defenses is that the injury was caused by intoxication. If the injury was not caused by intoxication, then it will qualify as a compensable injury. But if it was caused by intoxication, either by alcohol, controlled substance, etc., then that claim is not subject to compensation liability. That's affirmative defense number 1. Affirmative defense number 2, where the injury is not intentionally self-inflicted, and we talk about self-inflicted injuries already. Believe it or not, employees will self-inflict injuries for the purpose of obtaining benefits. And this is one of the defenses that employers use to deny compensation for those cases. Where the employee has not willfully and deliberately caused his or her own death. Sounds a bit crazy, but if you're going to commit suicide, you might as well do it on the job where there are benefits, right? But that can be defeated if it's found to be deliberate. Where the injury does not arise out of an altercation in which the injured employee is the initial physical aggressor. Do you think you'll get these kind of cases? I'm telling you, it's crazy, but you do. A person claims an injury at work, and investigation of the incident reveals that the injury is due to a fight. It was a fight at work. They refer to it as an altercation. There was a fight at work, and then the dispute comes down to who was the initial physical aggressor, okay? If the initial physical aggressor is injured during a workplace fight, that person does not qualify for compensation. There's no liability on the part of the employer for that person's injury. If there was a workplace fight and the person who was the recipient of the initial physical aggression, if that person is hurt, that person qualifies for compensation liability. So how this plays out in your evaluations is you'll get these cases where the employer will send you a sub-rosa videotaping or workplace videotaping that shows this altercation going down. And it'll show the person either being the initial physical aggressor or being the recipient of the initial aggression. And that's more of an administrative defense. It's not a medical determination as to who was the initial physical aggressor, but still it comes to you as a medical dispute as to, what is the nature of the injury? Is it possible that this injury was caused by this fight? In other words, these cases come to us for these situations. And there's some very interesting cases where, the dispute has to be resolved all the way to the Workers' Compensation Appeals Board. I just read an interesting one about the two firefighters that got in an altercation, and it really came down to what constitutes physical aggression. Okay, verbal aggression most times is not the same as physical aggression. But the case that I just read was concluded that even verbal aggression, if it's performed physically or if it threatens physical action or physical harm, that can constitute the initial physical aggression. So these disputes happen all the time. Where the injury is not caused by the commission of a felony or crime, which is punishable as specified in certain section of the penal code, where the injury does not arise out of the voluntary participation in any off-duty recreational, social, or athletic activity, not constituting part of the employee's work-related duties. You'll get these cases all the time. I was at the company picnic playing in the softball game and tweaked my ankle rounding the bases. Except where these activities are a reasonable expectancy of or are expressly or impliedly required by the employment. Okay? So you can see that this can be a source of great dispute. Guy says, I was at the company picnic. I got involved in the softball game, tweaked my ankle. Employer says, we're not responsible for that. That's an off-duty recreational activity. The employer says, yeah, but my boss insisted that I play because he wanted our department to whoop ass on the shipping department. Okay. And you can see how these disputes can arise. Okay. So those are the affirmative defenses 4 through 9. You need to be familiar with those. These are defenses that the employer uses to try and get out of having to pay for benefits. Now, more common than any of these 4 through 9 is number 10. Okay. Now, right here, this is your source of work for the next 20 years is disputes that fall under section 10 of Labor Code section 3600. So we're going to go through this very, very completely, and then we'll take a break. You need to understand this because this will bring you more cases than almost any other single situation or scenario that you'll ever encounter. So let's go through this. It says, except for psychiatric injuries, okay, so we can just discard all those. We can skip this, except for psychiatric injuries. So all other injuries, all injuries, except for psych injuries. It says, where the claim for compensation is filed after notice of termination or layoff, including voluntary layoff, and the claim is for an injury occurring prior to the time of notice or termination or layoff. Okay, so let me make this real for you. Let's say a person gets a notice of termination or layoff on November 1st, 2023. Okay, let's make this real. The claim is filed after notice of termination or layoff. The notice is on November 1st. The claim for compensation is filed, let's say, December 1st. The claim is filed after notice of termination or layoff, including a voluntary layoff. And the claim is for an injury occurring prior to the time of notice or termination or layoff. Okay, injured worker says, I hurt myself on September 1st. They get a notice of termination or layoff on November 1st. They file the claim on December 1st where they allege that, hey, I hurt myself on September 1st. I didn't say anything. I didn't tell anybody. But I'm telling you now that you're going to lay me off, I'm telling you now, I hurt myself on September 1st. You get the dates and the timelines? Okay. It says no compensation shall be paid. No compensation shall be paid. It's the law. It's Labor Code Section 3600, Section 10. It says if you get a notice that you're going to be laid off or terminated, you can't go back and tell us that you hurt yourself before you got the notice of termination or layoff, right? Now, why would this section, why would this be in the law? Who even wrote this? Why is this here? This is here because lawmakers, legislators, have long known that employees who get terminated and or laid off want to retaliate against the employer. They want to get back at that employer. They want to stick them with a barb. They want to harm the employer. And they file these so-called post-employment claims. This is the post-employment claim. Section 10 is the section that deals with claims that are filed after the employment relationship has terminated between employer and employee. It says, for these types of claims, no compensation shall be paid unless, and then it goes into some unlesses. Unless, now, why do you think there would be some unlesses, some exceptions? Why do you think there would be some exceptions? Anybody?
It might actually be a valid claim.
There you go. There you go. It's to actually protect people who actually did have an injury. They just, for whatever reason, they didn't mention it, thought it would go away. They were fearful of losing their job, whatever, but they actually did suffer an injury. There are some protections built in. So it says, unless the employee demonstrates by a preponderance of the evidence that one or more of the following conditions apply. So again, this is the employee has to prove it. The employee has to prove it, and he has to prove it convincingly by a preponderance of the evidence. So the burden shifts to the employee here. The employer says, we're not paying. You filed this post-termination, we're not paying. The burden then shifts to the employee, and the employee has to prove that he or she qualifies for compensation. So here are some of the exceptions. Exception number one, the employer has notice of the injury as provided under 5400, 5401, and 5402. We talked about those a little bit earlier in terms of what constitutes notice of the injury. What constitutes notice of the injury is very, very flexible in favor of the injured worker. You know, I told my brother-in-law to call my boss's assistant. That can actually constitute notice under 5400. But if the employer has notice of the injury prior to the notice of termination or layoff, but just never acted upon it, then the injured worker is protected. It's one of the exceptions for the post-employment filing of a claim. They're protected, okay? Second is that the employee's medical records that exist prior to the notice of termination or layoff contain evidence of the injury. And I recently had this case. I had an injured worker, female. She's working at a Macy's, in the hair salon at Macy's. And she had some time off work. When she came back to work, her hair dryer that she used was gone, had disappeared somehow. And she had to use the standard issue hair dryer, which she said was heavier than her hair dryer. And for a period of time, she used this heavier hair dryer and developed symptoms and injury in her neck and upper extremity. Well, she then continued working, continued having these problems, and then she decided to open her own salon. And when she went through that transition between employers, between Macy's and her own salon, she filed a claim. She filed the claim post-employment. And of course, the claims administrator denied the claim because it was post-employment filing. And the law says here, no compensation shall be paid. But lo and behold, upon reviewing her medical records, sure enough, her medical records in the 9 months preceding her termination of her employment with Macy's, she was receiving medical treatment, and there was descriptions in the medical records of this heavy dryer, neck pain, shoulder pain, and all that stuff. But for whatever reason, she didn't file it while she was actively engaged with Macy's, but later she filed it, and she's protected because sure enough, she actually had suffered an injury. So she was protected. Third exception, this has to deal with specific incidences of injury, and this is going to make sense to you. It says that the date of injury, as specified in section 5411, and this deals with specific incidences of injury, specific incidences, not cumulative trauma, specific. It says the date of injury is after, subsequent means after the date of notice of termination or layoff, but prior to the effective date of termination or layoff. And that makes sense. So the injured worker gets a notice of termination or layoff on November 1st. And the notice says, by December 31st, you're no longer going to have a job because the plant is closing. We're moving to Texas. You're no longer going to have a job. Well, between November 1st and December 31st, that's 2 months of time. People can get injured in 2 months of time. They can legitimately get injured in that 2 months of time before the effective date of their termination or layoff. Okay, they can actually get hurt in that time. And the greater that time period is, the greater is the likelihood of them suffering an injury. So if they get injured in that time period, of course, they should qualify for benefits, and that protection is built in right here. And then finally, probably the one that you're going to have to really stretch your skull to get your mind wrapped around this has to deal with cumulative trauma injuries. And it says that the date of injury or cumulative trauma injuries, which is described in section 5412, is after the date of notice of termination or layoff, is after the date of injury, is after the date of notice of termination or layoff. So this has to deal with some subtlety that deals with the definition of the date of injury. This single exception to 3610, this is going to bring you more claims than any other single circumstances. This is what's referred to as the post-employment cumulative trauma injury claim, because section 5412 is what deals with the is what deals with cumulative trauma injury claims. So let's just chew on this for just a second. Let me see what I have for you on this. I think I have a whole discussion on this. Affirmative defenses, psychiatric injuries, and yes, I do. I have a whole discussion on this. So let's conclude with this, and we'll talk about this. So it said that when the date of injury, as defined under Labor Code 5412, is after the date of notice of termination or layoff. So the injured worker gets a notice of termination or layoff on November 1st, 2023, concludes his or her employment on December 31st, 2023, files a claim on March 1st, 2024, 2 months after the employment relationship has ended. Can that claim survive? Can that claim survive? Typically, the law says no compensation shall be paid, but this type of claim can survive if the date of injury under 5412 is after the date of notice of termination or layoff. So then we need to know about what 5412 says about the date of injury, okay? So real quick, under 5411, much more simple, the date of injury for specific injury claims is the date during which the alleged injury occurred. Very simple. For specific injuries, the date of injury is that date during the employment on which occurred the alleged incident or exposure, for the consequence of which compensation is claimed. Very simple. Okay, now 5412, a little bit different. Pay close attention to this now. It says the date of injury in cases of occupational diseases or cumulative injuries, like what? Like what's an occupational disease? How about skin cancer in a lifeguard? Okay. How about tuberculosis in a firefighter? Okay, these are the occupational diseases. And sometimes those symptoms, they don't manifest themselves until long after the employment relationship has ended, right? Okay, so there needs to be some protection for these types of people. So the date of injury is what gives them the protection. It says that the date of injury is that date upon which two things occur. Two things intersect to establish the specific date of injury. It says it's that date upon which the employee first suffered disability therefrom. Number one, first suffered disability. Okay, and disability, as we said, is two things. It's lost time from work, compensable lost time from work, and or a need for medical treatment. Well, on a post-employment claim, it's hard to establish disability because usually these people were fully working up until their last day of employment, right? Disability, that box is hard to check, but it's later when they require medical treatment, that box can be checked. The need for medical treatment can constitute the disability, okay? Is that date upon which the employee first suffered disability therefrom, and here comes number two now, second criteria, and either knew or in the exercise of reasonable diligence should have known, and you can imagine employers who are contesting these claims saying to the employee, oh, come on, you should have known that. You should have known that while you were working here. You didn't file this till after we fired you. You should have known that. And there's a whole dispute over this knowledge. Okay. Employee says, I didn't have any knowledge. Employer says, well, you should have had some knowledge. They either knew or in the exercise of reasonable diligence should have known that such disability, need for medical treatment, was caused by his present or prior employment. And what you're going to encounter most often is prior employments. You're going to have injured workers filing claims against their prior employer, especially if you're in Southern California. So this is the so-called post-employment cumulative trauma injury claim, which is very, very prevalent in the Southern California area. The epicenter for this particular species of claim is in the Long Beach, Los Angeles County area. If you're in that area, you're going to be seeing lots and lots of these post-employment cumulative trauma injury claims. Now, these are very, very successful species of claims that are very, very difficult to defeat or deny for this very reason. They're protected by Labor Code 5412, where the employee can say, I had no knowledge. I didn't learn or I didn't gain the knowledge until long after I left your employment. Now, in the case of occupational diseases, this makes sense. A retired firefighter develops a cough 2 years after their last day of work, goes to the doctor. The doctor says, what did you do your whole life? And the person says, I was a firefighter. And the doctor says, well, you're having asthma. And this asthma is contributed to by your career as a firefighter. And it's this day, the day when the doctor makes this revelation to the firefighter or the retired firefighter, that the firefighter gains the knowledge that his cough is due to the present or the prior employment. So this provision of Labor Code Section 3600, Section 10 protects those people. Now, it makes sense in the case of occupational diseases. It's my opinion that it makes less sense for cumulative trauma, musculoskeletal injuries, but you're going to get those cumulative trauma, musculoskeletal types of injury cases all the time. And it's because Labor Code Section 5412 is bringing them to you. Okay, so there's some basic definitions and injury situations and a lot of important labor codes for you to understand. Let's take a quick 5-minute break and then we'll come back and we'll shift gears a little bit. So I'll see you all back in just about 5 minutes.
Dr. Carpenter,
Yes.
just real quick, I had an employee that worked for me for a year. She stated she had a workers' comp claim on her shoulder, which I never saw after we hired her. She disclosed it. And I think she got COVID a couple times and then just decided to go away. But she started saying to me before she left, her wrists are hurting because of the carpal tunnel she had, which she did not disclose when I hired her. So we got a hold of HR and they said she can go back a year after she left. She left. It was her choice. She could go back a year and come back to our office and say the carpal tunnel was irritated by our office because we had a genie that she had to rub people with. But her carpal tunnel actually started before the job before us, which I think she was having treatment for even before she was hired by us, which she did not disclose. So very interesting how the carpal tunnel is going to be huge, especially I think in California, how they can go back and say, oh no, I was treated for this and your office made it worse. And now that I'm not employed with you, I'm letting you know that I'm coming back. And HR said that she could go back at least a year with us.
She can go
and
back,
go back to
indefinitely.
Okay. So yeah, so I was like, ooh, that doesn't protect us very much unless I would have a case where she did not disclose it. But I did, as soon as she started complaining about workers or carpal tunnel, I pulled her off the vibrator and I pulled her off anything that could irritate it. But that's another tough one because that's very cumulative, right? As you do stuff, especially computers and stuff. So that was I don't think I think I'm gonna get this one right on the test because it's just so familiar,
You're gonna have to provide benefits to her because very, very difficult to defeat for this very reason right here. So there's
Yeah.
this
And
concept
she
in
could
workers.
totally do it if she wanted to.
Yeah, she could come back. You're gonna see this.
Interesting.
Dr. Carpenter,
Yes.
what if two employees who clocked off the work and then they got into an altercation, physical, verbal, or in the parking lot of the practice or the business? What kind of compensation or how does that factor into what it's called? They clocked off, they were out, done, finished for the day, but it happened in the parking lot of the business.
And you're going to see those cases all the time, parking lot cases. So whether or not the person is going to ultimately qualify for benefits or not, that's an administrative determination. It's not a medical determination. So that has to be decided administratively. If they were off work, off duty, but they may say, that they were getting ready to do an errand for the employer, or the employer asked me to drive Jimmy home. And I was just driving Jimmy home, getting ready to drive Jimmy home. And we had this altercation in the parking lot. So those are administrative issues. Those are going to be resolved administratively, but they may come to you for a medical determination for, some assessment as to whether or not there's an injury, whether or not what it is that they're complaining about could have been caused by this altercation. So that's where we as QMEs need to be very, very clear on the distinction between AOE and COE. So as qualified medical evaluators, we opine on AOE. We don't opine on COE. So the parking lot incident that you're talking about, the argument is, hey, did this occur in the course of employment? That's not your determination as the QME. That's ultimately going to be determined by the trier of fact, because that's a factual determination. It's not a medical determination. So COE issues are not your issues. Your issue, Dr. Patel, you're a dentist, correct?
Yes.
So your issue is, did the guy suffer some dislodged teeth as a result of this incident? Did he suffer a dislocated jaw as a result of this incident? They come to you for the medical determination. Meanwhile, they use your findings on the medical determination in arriving at the COE determination. Isn't that interesting? Is that clear?
Yeah, but for the sake of say the test, I mean, if there's a question, is it compensable or not? You know, A, B, C, D. You know, so does this become, what kind of options would this kind of a scenario have if it were a test question?
If it were a test question, I'm just speculating, but I'm thinking it would come down to whether or not it arose out of or occurred in the course of employment. So if they say, you know, Jimmy and Johnny were running errands, were getting ready to run errands for the employer, that would be an altercation that occurred in the
Yes.
course of employment.
Yeah, but
If they were off duty, getting ready to go to a bar or a basketball game, I would answer that it would be not compensable because it did not occur in the course of employment. For our purposes, you can see that there's 1,000 gray areas in there, right?
Yes, yes, yes. Thank you.
Okay. All right. I'm going to take a quick break. I'll be right back with you. Okay, can you hear me now?
Yes, I can hear you.
Okay. You got anything to say about that last section there, Sid?
No, I thought it was really interesting, all the cumulative trauma stuff you were talking about. When we took the seminar with Dr. Music, because he was hitting on so many different topics, I don't think we hit this topic as much to really eke out the differences between the specific and the cumulative trauma injuries and how those exceptions can exist too. So that was very helpful.
Good, good. You're gonna get a lot of them. You're gonna
Okay.
get the the minority of your cases are gonna be the specific injury cases. The majority are gonna be cases that involve some component of cumulative trauma. So for example, you'll get a singular cumulative trauma injury claim, or you'll get a claim that alleges both a specific and a cumulative trauma injury claim. Now, why is that? Why is that? The reason for that is that the specific injury claims have a very narrow statute of limitations. They have a 30-day statute of limitations. So many claims will not survive on the basis of the specific injury claim because the statute of limitations has already told or has already expired. Many times the only hope for survival of the claim is on the legs of the cumulative trauma injury claim. So you're going to get a flood of cumulative trauma injury claims. So you gotta wrap your head around those cumulative trauma injury claims. You're gonna get a throng of them. It's gonna make sense, some of these things that we've talked about, when you start getting your first few cumulative trauma injury claims. Okay, other comments, concerns before we move on? Anybody? I'll give opportunity. Okay, so
Dr. Carpenter, quick question. When the little clause about when a reasonable person would have been aware, is that something that employers can then go back and say, you probably should have been aware of this, long before, therefore we're past the statute of limitations? Okay.
yeah, that's a whole dispute.
Yeah, got it.
Injured worker says, no, I wasn't aware. So what constitutes awareness? Typically, this isn't a complete answer, but the cases that I'm familiar with that deal with this issue, typically knowledge is gained when it's provided by a medical provider. So the guy goes to the doctor for the first time with his cough, and the doctor says, this cough is due to you working in the coal mine your whole life. And the guy says, really? I never knew that. I just learned that when my doctor told me it just yesterday. So it's usually when the medical provider, gives them the revelation that, hey, this is due to your former employment. That's usually what constitutes knowledge from the cases that I've read.
Thank you.
Questions before we go on? So let's go on to some section 1 test questions. And this is new that we're doing for this particular test prep session that we've never done before. And we don't have a lot of time, but I do want to give you a chance to test your understanding of some of those concepts from our first section. So first question, what conditions must concur for an employer to be liable for compensation? Well, the injury must be caused intentionally. No, that's one of the affirmative defenses. The injury must occur out of voluntary participation. No. Number 3, the injury must arise out of and occur in the course of employment without being intentionally self-inflicted or caused by intoxication. This is the type of question you're going to get on the competency exam, where you have to synthesize some of the learning and put together a couple of different ideas to come up with the correct answer. Under Labor Code Section 3600, which of the following is not a condition that disqualifies an injury from workers' compensation coverage. Does it disqualify it if the injury arises from voluntary participation in occupation, off-duty recreational? Well, yes, that is, at least according to 3600. The injury occurs while the employee is acting within the course of their employment. Does that disqualify it? No, that's actually what qualifies it as an industrial injury. It occurred in the course of their employment. But it is disqualified if the injury was caused by intoxication or alcohol. The injury is intentionally self-inflicted. Okay. Next set, and I'll be quiet and I'll just let you read these here. So lean in close and read those. Okay, so what distinguishes a specific injury from a CT? You can see that options A and B have the definitions exactly reversed, correct? Specific injuries are a result of a single incident. CT injuries occur over time due to repetitive trauma over time. Can a condition that does not result in missed work or interfere with work ability be considered an injury under the workers' compensation system? No. A condition must cause disability or require medical treatment to be considered an injury. That's the correct answer. So, very, very interesting. So injury, many times you're going to be called upon to tell us, does this person have an injury, right? Imagine there's a denied claim. The claims administrator says, no, let's send them to the QME. Let's have the QME tell us, is there an injury? Okay, so what constitutes an injury? An injury. So the question is there an industrial injury or not? That's the question that the parties need you to answer. So it's very, very interesting. In order for there to be an industrial injury, there must first be an injury. Before you can have an industrial workplace injury, there must first be an injury. If there's no injury, there can be no industrial injury, right? So therefore, what is it that constitutes an injury? Well, injury is very carefully defined in the California workers' compensation system. And this is the type of algorithm that you're going to go through when you're confronted with these type of cases. Does the injured worker have an injury? So what is an injury? Well, an injury, as it's defined in California's workers' compensation system, is a condition. A condition. The examinee must have a condition first. And then that condition must rise to a certain level. It must rise to a level that it either causes disability, just lost time from work, and or a need for medical treatment. Not every condition constitutes or qualifies as an injury. Okay, now pay close attention to this. You got to get this. People are going to present to you with conditions, right? They're going to have positive objective findings on their physical exam. You're going to make a diagnosis for a bona fide condition. They have a condition. Okay, so they have this, they can check this box. They have a condition. Now, does that condition rise to the level that it meets the criteria for an injury, as injury is defined in California workers' compensation? See, this is a different system. This is workers' compensation. Might be different from how you define injury in your clinical practice. In workers' compensation, an injury is a specific beast. It's a condition that either causes disability and or a need for medical treatment. You might be confronted with injured workers or injured workers claiming an injury that have a condition, but in your opinion, it doesn't really need medical treatment, or it's not expected to be something that responds to medical treatment, right? Not everything requires medical treatment. I got about 9 conditions going on myself. And, you know, I'm sure you have some of those yourself. They're just, you know, they just don't need any treatment, or there's not treatment's not going to help it. Okay. So in order to constitute an injury, the injury, you must first have a condition, and then that condition must rise to a certain level. It must meet a few criteria. So only conditions that require medical treatment or are causing disability constitute an injury in California workers' compensation. The best way to deny industrial injury is to find no condition. If you find no condition, the argument's over. If the examinee has a normal physical exam, the argument's over. Okay, this is something that's going to become into play when you see these post-employment cumulative trauma injury claims, where the claimant is claiming 10 different body part injuries. And if you find no condition in any of those body parts, then there can be no industrial injury. Very, very interesting. And then that was it. So we have a couple of questions. Okay, so let's move on now. Let's talk about, let's get into now the QME study guide. Now, the QME study guide is a fascinating and very valuable resource for you. This is what the Division of Workers' Compensation has provided for us for prospects who are getting ready to sit for the QME competency exam. It's their interpretation of what is important information for us to understand. So we're going to go through the QME study guide with a fine-tooth comb. And I'll help you on some of the important aspects, and then I'll assign you some responsibility to study on your own some of the other aspects that are not as relevant immediately. So let's start with very first section of the QME study guide, which is section 1, accreditation and reaccreditation. And as I explain some of these things to you as we go through this document, this is where you're going to get the aha moments, where I'm going to give you the practical application as to how these various laws and all these rules apply in your practice. So real quick, let's take a look at the QME study guide, which is a PDF document here. QME study guide, here it is. So you have this document. I gave it to you in your handout materials. This thing, the most recent edition, was written in May 2017, and we have had some changes in the laws and regulations since then. So where applicable, I'll point out those changes as we encounter those. So here's the table of contents. And we're just going to go through these one by one. Chapter 1 is QME accreditation, permanent disability determination. So we're going to pick these off one by one, and you're going to have a good understanding of all of these concepts. So the first one to talk about is QME accreditation and reaccreditation. This is described in this exhaustive, lengthy labor code, 139.2, which is always like a piece of bubble gum on the bottom of your shoe. It just is always there telling us what we need to do. So let's take a look at 139.2. Okay, so just go through the relevant sections here. It says the administrative director, talking about the Division of Workers' Compensation here, shall appoint QMEs in each of the respective specialties as required for the evaluation of medical legal issues. And we have a variety of specialties in the group here today. We have dental providers, chiropractic providers, medical providers. We have a variety of specialties. The appointments shall be for 2-year terms. So when you get your appointment, you're going to get your appointment in around June of 2024. So then your next renewal cycle will be June 2026. You get a 2-year term. Administrative director shall appoint or reappoint as qualified medical evaluators a physician as defined in section 3209. And then here as the various types of physicians, they're medical doctors, doctors of osteopathy, chiropractors, psychologists, etc. Those are the types of physicians that get appointed as QMEs, as long as he or she meets the requirements in paragraphs below. And we're going to go over these paragraphs now. So the first is that you pass the QME competency exam. That's what we're studying for now. Right now, the non-chiropractic providers must complete a course on disability evaluation report writing. This is the pathway that non-chiropractic providers take to the QME competency exam. We provide this course. If you need this course, you can get it from us. Chiropractors have a different path. We'll talk about that shortly. Second requirement is that, and also this 12 hours of instruction, this applies only for this cycle. The next cycle is going to be 16 hours, okay? You must also devote at least 1/3 of your total practice time in providing direct medical treatment. Doesn't have to be providing workers' compensation medical treatment, but you know, the whole spectrum of medical treatment in your practice, 1/3 of the time. So if you get in deposition and the attorney that's deposing you starts asking you questions, they're going to ask you about your practice time. So make sure that you tell them and confirm to them that, yes, I devote at least 1/3 of my practice time to providing direct medical treatment. That's what's going to apply to most of you in this group. Okay, there are exceptions, but most of you are still going to need to be, you know, at least in 1/3 practice time. Now you can tell that this is sort of a vague definition. Like my total practice time is only 1 day a week, right? I'm only in my practice 1 day a week. So yeah, I do one morning a week. Does that constitute 1/3? This is sort of a vague definition, but if you're ever asked upon it, you want to say that you provide 1/3 of your time, okay? The exception to that is if you've served as an agreed medical evaluator on 8 or more occasions in the 12 months prior. This is basically a full-time agreed medical evaluator. This is not going to apply to you, okay? Very, very rare to get 8 AMEs in a 12-month time period. There are a few that get that, but they are the exception for sure. Okay, then it talks about some specific requirements for osteopathy doctors, talks about specific requirements for chiropractic doctors, specific requirements for psychology providers, talks about not having a conflict of interest that would in any way interfere with your ability to be an objective qualified medical evaluator. Now, there are exceptions for physicians who are retired, and I'm a retired physician. So I qualify to do QME evaluations on a retired basis. On a retired basis, you have to be able to document that you've been in active practice for 25 years, and now you're beyond your 25th year, and you're no longer involved in full-time clinical practice. So I have a retired exemption in the past. I've also had a teaching exemption. If you hold a teaching position, and you can document your teaching and that teaching takes you out of full-time practice, you do qualify to be a qualified medical evaluator. I had a period of time in my career in 2005, 6, 7, 8, 9, in those areas, in that time period there, where I was teaching anatomy at the local community college on a nearly full-time basis. And so that took me out of my clinical practice. But still, I qualified to do QMEs, and I was doing a ton of them in those days. And it was the teaching position that freed up the time from the clinical practice to be able to do full-time QMEs. So those are your exceptions. There might be a couple in our audience that might use the retired physician exception. Okay, and then let's continue. So this is where 139 rears its ugly head all the time and sort of serves like the schoolyard enforcer. it says the QME shall, upon request, shall be, so you have to reapply. It says upon request, you have to reapply. Shall be reappointed if he or she meets the qualifications and meets all of the following criteria. So here's the one I want to point your attention to. That you have not had more than 5 of your evaluations rejected by the workers' compensation law judges or the appeals board during the most recent 2-year period during which when you served as the QME evaluator. If the workers' compensation administrative law judge or the appeals board rejects the QME's report on the basis that it fails to meet the minimum standards for those reports that are established by the administrative director of the appeals board, the judge or the appeals board, as the case may be, shall make a specific finding to that effect and shall give notice to the medical evaluator and to the administrative director. So they'll give a notice to you. They'll also give a notice to the administrative director down at the DWC. Any rejection shall not be counted as one of the 5 until the specific finding has become final and the time for appeal has expired. So there's a push now for improving the quality of QME reports. And I'm on a committee at the DWC. It's known as the Report Quality Committee. The whole purpose of the committee is to somehow, some way, crank up the quality of the population of QME reports that are circulating out there in the industry. So there's a push for it. Part of the push includes enlisting the help of the workers' compensation judges. We're now going to the workers' compensation judges and asking the judges to help us identify low quality and substandard reports. Now, it's just what the judges need is another thing to do, right? So, but the judges are getting on board and they're helping us identify low quality reports so that low quality reports can be brought to the attention of the medical evaluator, not so the medical evaluator can so much be disciplined, but more so that the medical evaluator can be educated about how to bring their reports up to the minimum standards such that the reports can actually be used by the parties to resolve difficult issues. So if you have 5 reports rejected in a 2-year period, you should probably dismiss yourself because this is probably not the type of work for you. 5 is a lot, and a 2-year period is very, very lenient, very, very lenient, right? It's not like 5 reports in a 5-year period, 5 reports in a 2-year period, or not 5 reports in a 1-year period, it's 5 reports in a 2-year period. It's very, very lenient. And it's not going to happen to you, but there is a process in place for having you removed if your reports just are more of a problem than they are a solution to the system. You must complete within 24 months, at least now 16 hours of continuing ed and impairment evaluation. Now, if you see this question on the exam, 24 months and at least 12 hours, what should you answer? Is the correct answer 12 or is the correct answer 16? It's going to be 16, but I don't think 16 is going to show up on this particular exam cycle. 16 is going to be for our next exam cycle for sure. If you see 16, I would go for 12. If 12 is an option. If 12 is not an option, then the answer would be 16. You have to prove that you've not been terminated, suspended, placed on probation, or otherwise disciplined by the administrative director during his or her most recent term as a QME. Okay, so 139.2 is a labor code that governs many of the activities of the qualified medical evaluator. So we're not going to go through all of it due to time constraints, but you should review this in its entirety and just get the big picture of what it's talking about. In a bit, we're going to get on to some discussions and descriptions where the term good cause comes into the conversation. And so since we're on it here right now, let's talk about what constitutes good cause. This is what good cause refers to when we're talking about canceling appointments, rescheduling appointments. We're going to talk about when you can and when you cannot cancel appointments. So for example, you cannot cancel an upcoming QME appointment less than 6 days before the evaluation, unless there's good cause. Okay, you cannot submit your report later than 30 days after the face-to-face evaluation unless you have good cause. Okay, so here's where we find the definition of good cause, and it's a very stringent definition. It says that there's a medical emergency in the evaluator or the evaluator's family, for which you'll have to provide documentation, by the way. You can't just say it. A death in the evaluator's family constitutes good cause to either cancel an appointment or submit a late report, or there's a natural disaster or other community catastrophe that interrupt the operation of the evaluator's business. That could constitute good cause. We used good cause. We used the COVID pandemic once or twice during the COVID era to justify a couple of late reports that some of our doctors had. We said that COVID was a situation that caused the disruption of their practice, and we elaborated on that a little bit, and the Division of Workers' Compensation was okay with that. So good cause is very strictly defined. We'll come back to good cause here in a little bit. Okay, so we went over 139.2. Let me show you the QME regulations. Well, first, let's define physicians as defined in Labor Code 3209, because we just referred to that in the other section. So here's the definition of physician as relates to California workers' compensation, that is. Physician includes physicians and surgeons holding an MD or DO, psychologists, acupuncturists, optometrists. We have optometry QMEs. Did you know that? We have optometry QMEs, and I know an optometry QME who's sitting for this round of the exam. Dental providers, podiatrists, chiropractic practitioners, and even acupuncturists, as we already mentioned. These are what are considered physicians, at least in terms of becoming qualified medical evaluators in the state of California. The QME regulations, I provided these for you as well. I want you to take notice of this website. In fact, I'll put it in the chat. Let's see. I'll put it in the chat right now. This is a chat that'll go to everybody. So here's a website that you can go to have easy access to all of the QME regulations. It's sometimes hard to find if you just do a Google search on it. So having that website that I gave you will help. So it has all of the QME regulations from 1 all the way to, this is 159. So here's the QME regulations here, 1 through 159. So you can peruse these on your own and become familiar first with the major topic headings here, and then all of the subsections within each of these sections. So here's, for example, section 40. We're going to go over some of these specifically here in a couple minutes. So this is something that you'll refer to, fairly often. And I recommend, just going through the QME regulations every 6 months, something like that, just to keep yourself fresh on the rules and laws that govern all of our actions and behaviors. Okay. Okay, so let's continue. So I'm going to make sure I handled all of accreditation and reaccreditation. Okay, so that's accreditation and reaccreditation. Let's go on to now section 2 of the QME study guide, which is permanent disability determinations for all of us that are doctors. This is going to be a lot more interesting and a lot more fun. So we're going to permanent disability determinations in section 2. apportionment, disputes, the QME panel process, and we'll finish up with the life cycle of the QME evaluation. Okay, so let's go to permanent disability determinations. Okay, so this is fascinating. So we're called upon to render permanent disability and apportionment determinations. The permanent disability and apportionment determinations, the permanent disability we're going to derive from the AMA guides. And every time you offer an opinion or conclusion on either permanent disability or apportionment, those opinions that you provide must rise to a certain level. They must rise to the level that's referred to as substantial medical evidence. Have you heard this term? Grunt if you've heard the term substantial evidence or substantial medical evidence. You heard that?
Yeah.
Yeah. So we're going to define that, and I'm going to show you how to fashion all of your opinions and conclusions such that your opinions do rise to the level that they're considered to be substantial. We're going to talk about rating by analogy. You've probably heard of this as related to the Alvarez and Guzman cases. I'll tell you all about that. We'll talk about industrial cancer, and then here's the references for this particular section of this discussion, permanent disability determinations. So let's go to the QME study guide.
Yes.
And go into this section, permanent disability determinations. And you see I highlighted all of these topic headings here. Okay, so let's go page 6. Okay, so this is where you're going to get some aha moments. So as we said, California workers' compensation laws must be liberally construed with the purpose of extending benefits to protection of persons. So this is liberal construction. This is applicable to all aspects of workers' compensation law, including permanent disability and apportionment determinations. So the tie goes to the injured worker. Okay, you can be generous in favor of the injured worker. The law allows for it. The permanent disability evaluation occurs when an injured worker is permanent and stationary. That is, when the worker's condition has reached maximal medical improvement and is unlikely to change substantially within the next year with or without medical treatment. So let's think about this for a sec. So one of the opinions that you offer in the body of your report is the injured worker permanent and stationary, or are they not permanent and stationary? How do you make that decision? How do you determine if they're permanent and stationary? Well, one way you make that decision is you ask yourself, is their condition likely to change substantially, that is, in the next year with or without medical treatment? Sometimes you'll be tempted to declare the injured worker to be not permanent and stationary. If you declare the injured worker to be not permanent and stationary, and you recommend additional medical treatment, you better be pretty sure that that recommendation for medical treatment is going to make a substantial change, right? If it's not going to make a substantial change, don't recommend it. Don't put everybody through that. Don't put the injured worker through it. Don't make the claims administrator pay for it. Don't get everybody all geared up if it's not going to make a substantial change. Do you get it? This is where you're responsible as a qualified medical evaluator to do the right thing. And sometimes you have to make hard decisions. So if you determine that I don't think they're going to substantially change, we could give them chiropractic, acupuncture, physical therapy, injections. If they come back in 6 to 12 months and they're the same, well, then you made the wrong decision, correct? So this is where you have to make the difficult decisions. And that's sort of the thinking process you'll go through when you face yourself, when you get to those crossroads. To ensure And then in the body of your report, to ensure that injured workers obtain the benefits to which they are entitled, the examining physician must fully and completely report their findings, must fully and completely report their findings. And this is where your communication skills come in. This is where QMEs struggle. You know, most QMEs are outstanding, fabulous doctors. They're not always such great communicators, especially communicating in writing the medical reports. So clarity, clarity, clarity is essential. Before you put something on paper, make sure it's clear in your head, because clear writing flows from clear thinking. So you have to be clear in your own head before you put it on paper. Disability determinations. So we're in the permanent disability determination section. Disability determinations are based on the permanent disability rating schedule. That's a method for determining the nature and extent of the occupational injury. That's something that's handled down at the disability evaluation unit. For those of you that are chiropractors and you went through Dr. Music's program, I know he spent some time on this, but it's not something that you're going to have to deal with. This is something that's dealt with down at the disability evaluation unit. Your job is to provide the impairment rating. For injuries occurring on or after January 1, 2005, the permanent disability rating schedule uses the AMA guides to the evaluation of permanent impairment. So you all need to have the guides. I suggest you also get an electronic version of the guides, since you're going to be on your computer all the time. It's well worth the money, and you're going to use the heck out of it. So, you know, get a copy of the guides and electronic guides. You got to have the guides. Don't tell me you don't have the guides, okay? You got to have the guides. You also need to have each and every one of the exam instruments that are described in the guides that's associated with your particular specialty, okay? The AMA guides, as the starting point of permanent disability determination, examines a specific medical impairment's impact. Key words here now. It measures the medical impairment's impact on an individual's activities of daily living, such as dressing, bathing, eating, ambulating, toileting, and attending to personal hygiene. Now, there's a table in the AMA guides, table 1.2. Here's where the AMA guides provide an example of activities of daily living. There are other examples of activities of daily living that you can find from other references. And the AMA guides have additional scales in here for other activities of daily living. They have this one here, the IADL. They have several. But this is the table that you can rely on. And this is the table that you should use when you do your assessment of activities of daily living. Okay, so listen very carefully. When it comes time for you to provide your permanent impairment rating, your findings on your activities of daily living assessment are as important as your physical examination findings. You might find yourself tempted to focus on your totality on the physical examination findings, but your findings on your activities of daily living assessment is as important, because you're required to tell us, how does the impairment impact the activities of daily living? The guides tell us if the impairment does not impact activities of daily living, that qualifies for a 0% impairment. I think I have that right here. Yeah, here it is. Here it is. This is the necessity of a good activities of daily living assessment. It says here on the bottom, a 0% whole person impairment rating is assigned to an individual who has an impairment. They have an impairment. But the impairment has no significant organ or body system functional consequences and does not limit the performance of the common activities of daily living indicated in table 1.2. So as you go through your evaluation with the injured worker, you're going to be asking the injured worker, Mrs. Jones, let me ask you, as a result of your fill in the blank, neck pain, back pain, digestive upset, cardiac arrhythmia, vertigo, whatever the condition is, as a result of your condition, do you have any limitations in using the bathroom for urination? No, I can use the bathroom just fine. Do you have any difficulty or limitation in using the bathroom for defecation? Yes. Yes. Because of my back, I have sometimes trouble getting down on the toilet, and I have trouble cleaning myself up after using the toilet. Okay, I understand. I understand. You have difficulty using the toilet and difficulty cleaning yourself after using the toilet. Is that correct? Yes, that's correct. Okay, so let me ask you, Mrs. Jones, are you able to use the toilet? Are you able to use the toilet for defecation? Or do you have to have assistance using the toilet for defecation? No, I'm able to use the toilet for defecation. It's hard getting up and down. And you ascertain that she has no limitations to the activities of daily living involving defecation. Mrs. Jones, as a result of your back and neck pain, do you have any difficulty with sexual function? Are you able to have sex? Oh wow, it's not like it was before. I know, I understand that, but are you able to have sex? Yes, but I cannot do certain positions. My husband has to help me out. Mrs. Jones, let me ask you, as a result of your neck and back pain, are you able to have sex or you're not able to have sex? I'm able to have sex, but it's just not the same. Okay, I understand. And they have no limitations to the activity of daily living of sexual function. And so, do you get that? So your determination on your activities of daily living assessment is as important as your physical examination findings. So you need to get very, very good at doing an activities of daily living assessment. It can only be done in the face-to-face evaluation with the injured worker because it has to be interactive so that you can go through this process that we just went through like we just did. Any questions on that?
Yes, I have a question,
Go
Dr.
ahead.
Carpenter. I wanted to find out, okay, so let's say someone comes in and you do the disability determination and you actually find that based on that rating guide that you showed in table 1.2, that they actually don't have any effects to the disability aspect of it, then in the physical exam portion, when you do that, you find some, but it doesn't corroborate like a real injury. What would you do in that situation?
Well, you would either rate them either provide them no impairment rating or a very, very low impairment rating. If your physical examination findings are consistent with an impairment, but they have very few or only subjective limitations to activities of daily living, then you would either provide them no impairment rating or a very low impairment rating. So most of the impairment charts and tables in the AMA guides provide for a range of impairment values. So you can either select, either no impairment or the lowest within the range.
Okay.
The guides say that if there's no limitations to activities of daily living, it doesn't qualify for a permanent impairment rating. And that makes sense. I mean, think about it. Think about it like this way. You're all new in this system. Before this system that we have now, we used to have a different system. We used to have a different system where we classified pain as either minimal pain, slight pain, moderate pain, or severe pain. And it's kind of has some overlap with our current system. Well, in the old days, a slight pain was a pain. We defined a slight pain as a pain that does not interfere with activity. So imagine a basketball player comes off the court at halftime and he says, "Coach, my knees are killing me." And then goes out in the second half of the game and scores 20 points. Well, how bad is that pain in his knees? It obviously doesn't interfere with activity, correct? The guy scored 20 points, got 10 rebounds, okay? Well, similar in our current system, the guides tell us that if you have an impairment, but it doesn't interfere with activities of daily living, it's a minimal or slight or non-existent impairment. It doesn't qualify. If it doesn't impact activities of daily living. See, it says the AMA guides as the starting point of permanent disability determinations, examine a specific medical impairment's impact on an individual's activities of daily living. And it goes into all those activities. So you're going to find when you interview your examinees for the most part have few limitations to activities of daily living. They dress themselves to come to the appointment. They're groomed, they're bathed, they drove themselves to the appointment. They walked down the hallway to the appointment, okay? So it's your job to ferret out true limitations to activities of daily living when they're there so that you can provide the appropriate and accurate impairment rating when it's appropriate and accurate. The AMA guides are, of course, only a tool in its proper use and application by a QME with medical expertise and ability to exercise clinical judgment to evaluate an individual worker's level of permanent impairment cannot be overstated. So, Sid, this is where your expertise as a medical evaluator comes in. And whatever impairment rating you decide to provide for this injured worker, whatever it is, in your clinical judgment, whatever you think that they most accurately qualify for, you're going to have to explain it, okay? And your explanation of it will carry the day or will sabotage the whole argument. It's basically how you explain it determines whether or not it'll be upheld. We'll talk about that in just a second when we get into substantial evidence. QMEs are expected to know basic principles of workers' compensation laws related to QME responsibilities and the AMA guides as discussed below, okay? So let's go on now. We're talking about permanent disability determinations. And when you provide a permanent disability determination, that's a money conclusion that you're providing, correct? You're providing a money conclusion. Well, if you're anything like me, anytime somebody approaches you with a money question or concern or demand, I usually start around with a series of questions that begin with the question, why? Why? Why do I need $1,000 car repair? Why do I need to have my roof replaced? Why do I need an implant, a dental implant? Why? Right? The parties are like kids. They always want to know why. Why do you say such a thing? And for the first time ever, probably in your career, you're going to be called upon to have to support your opinions and conclusions with what's referred to as substantial evidence, substantial medical evidence in this case. So let's talk about what constitutes substantial medical evidence. So substantial medical evidence has been defined through hundreds and thousands of case law cases. Here in the QME study guide, they cite a couple of the more prominent cases. So they tell us that substantial evidence is relevant evidence that a reasonable mind might accept as adequate to support a conclusion. Relevant evidence, adequate to support a conclusion. So you're going to be providing conclusions. You're going to be providing a lot of those, like the injured worker has 10% lumbar spine impairment, 20% right elbow impairment. You're going to be providing these conclusions, but you have to be able to provide the relevant evidence that supports the conclusion. Okay, you can't just give the conclusion. You have to give the support for the conclusion. To constitute substantial evidence, a physician must conduct an adequate exam and an adequate history. It doesn't say adequate history here, but I'm sure it will later. So it must conduct an adequate and comprehensive exam before making an impairment determination. So if you're anything like me, you probably wonder, well, what is an adequate exam? What is a comprehensive exam? Do you think that your exam will be adequate? Do you think your exam procedures that you now use in your clinical practice would be adequate to support a conclusion in workers' compensation? Maybe, maybe not. What I suggest is that an adequate exam is an examination that exactly follows the AMA guides, okay? In each chapter of the AMA guides, there are specific examination procedures that are described. There are specific examination instruments that are described. I suggest that you fashion your workers' compensation QME exam to exactly comport with the AMA guides. Okay, for you that are chiropractors, okay, there's no description in the AMA guides of Kemp's test. There's no description of Milgram's test, okay? We don't want to know what Milgram's test showed, okay? Your examination has to change to be considered adequate and comprehensive in this particular realm, okay? The different hats from what you wear in your clinical practice to what you're going to be doing in your QME practice, okay? Okay, next, a medical opinion is not substantial evidence if it's based on facts no longer germane, if it's based on inadequate medical histories or examinations. That's where if I was a defense attorney or an applicant attorney and I didn't like your opinion or conclusion, I would attack your exam. I'd go right for the exam. Doctor, did you do digital inclinometric range of motion measurements on the lumbar spine? Did you do it 3 times? Did you do a warm-up? I would go right for your exam because most exams are not adequate. Okay, you want your exams to be perfectly adequate, better than it, okay? If it's based on incorrect legal theories or if it's based in any way on surmise, conjecture, speculation, or guess, okay? So let's take a look at this a little bit. It says, the medical opinion is not substantial evidence if it's based on facts no longer germane. So what then would make a opinion substantial? What kind of facts are required in order for the opinion to be substantial? Well, it has to be based on facts that are still germane. I like to think of these as relevant facts. Germane means relevant. So your opinion must be based on relevant facts, facts that are relevant to the opinion. Not just facts. They have to be relevant facts. They have to be germane facts, facts that are germane to the opinion. Okay, I wear a size 10 shoe. That's a fact. It's not germane to what we're talking about. Your facts have to be relevant to the opinion and have to support the opinion. Okay? I'll share with you some examples about that. And this may be a new way of thinking for you. Once you get it, and once you can do this, I'm telling you, your phone is going to ring off the hook. Because the whole system craves substantial opinions. They're looking for doctors that can substantially resolve disputes and move these cases on. Cases can only be moved on based on substantial opinions, not just opinions. They have to be substantial opinions. In order to constitute substantial evidence, a medical opinion must be predicated on reasonable medical probability. How would you do that? How would you do that in the body of your report? How do you predicate your opinion on reasonable medical probability? You do it like this. You say, in my opinion, within reasonable medical probability, and then you give the opinion. You predicate it on reasonable medical probability. Now, reasonable medical probability means that it has a 51% or greater likelihood of being correct. If you're not 51% or greater likely that you're correct, don't say it and change the opinion. If you can't say it, don't provide the opinion. It has to first be 51% or greater likelihood of being correct. This is like the first filter the opinion has to go through, right? Your opinion is going to be passed down a series of filters. A correct, accurate, true, and substantial opinion will fall out the bottom of the filters only if it's correct, only if it can pass through these filters. And this is the first truth filter. It has to be 51% or greater likelihood of being correct. Also, a medical opinion is not substantial evidence if it's based on facts no longer germane. We already said this. Further, a medical report is not substantial evidence unless it sets forth the reasoning. The reasoning, they should put this in capitals, behind the physician's opinion, not merely his or her conclusions. Okay, so this is so important. So imagine you're at a backyard barbecue and you're talking and you're talking, you're in a social setting. And so we do this all the time in social settings. We render opinions and we say things like, the Chiefs are the best team of all time, right? You're at a backyard barbecue and someone says, the Chiefs are the best football team of all time. That's an opinion. That's an opinion that offers a conclusion. The conclusion is that they're the best of all time. So that's one part of an opinion. That part of the opinion is called the conclusory portion of the opinion. The Chiefs are the best football team of all time is the conclusory portion of the opinion. Now, what comes after the conclusory portion of the opinion is what makes the conclusion substantial. And what comes after the conclusory portion of the opinion must be the reasons that support the opinion. So you're at the backyard barbecue and one of your comrades says, the Chiefs are the best team of all time. And you say, well, that's interesting. What are your reasons for saying that? Now, the quality of that opinion, the substantiability of that opinion that the Chiefs are the best of all time will hinge on the quality of the reasons. Now, if your friend has voluminous and compelling reasons, the more reasons and the more compelling the reasons, the more likely true is the conclusory portion of the opinion. Isn't that interesting? So your friend comes out and he says, oh, they just are. And by the way, you know, the Patriots suck anyway. Not a very compelling reason, correct? Not a very substantial opinion. But if your friend comes out and he says, well, the quarterback has the highest quarterback passing rating percentage of all time. The defensive line has the most stops of any line in the past decade. The center is the best and this and that. Fact, relevant fact. Facts that are relevant to the conclusion that they're the best of all time. The more compelling and the more voluminous of them, the more substantial is the opinion. Any comment on that? So can you see how you're going to have to start doing some work on your opinions and conclusions when you offer them in the body of your report? And I have an example to show you here. The QME must address the worker's history and symptoms, the results of his or her medical exam, results of various tests and diagnostic procedures, the diagnosis, the need for treatment and all this stuff, and the ability to perform activities of daily living. So there it is again. In making impairment determinations, a QME must use his or her entire range of clinical skill and judgment to assess whether or not the measurements or test results are plausible and consistent. Sid, okay, plausible and consistent with the impairment being evaluated. Further, an appropriate rating under the AMA guides for any illness or injury should take into account all impairments, not only the primary body part or organ system impacted, but the full impact of the illness and injury and its treatment. Sometimes the treatment can cause problems, like medication problems and digestive problems from all these NSAIDs and stuff like that. So you must consider the full impact of the illness, injury, and its treatment. Goes on to say different sections of the guides may apply depending upon the impact of any illness or injury and its treatment. And we have an example coming up to share with you regarding this relating to breast cancer. Only after consideration of all these factors may a QME compare the medical findings for each condition with the AMA Guide's impairment criteria and calculate the appropriate and accurate whole person impairment rating or ratings for each condition. Okay? So, activities of daily living and substantial evidence. Next, they talk about rating
Dr.
by,
Carpenter.
yes.
Quick question. Do you mind just explaining why we're expected not to comment on any impact of ability in the work environment? Is that correct? Just only on ADLs that exist outside of work.
That's what the guides tell us. Yes, that we're not to comment on work activities. You might know more about that than I do, but I comment sometimes on work activities, but I relate them to losses of activities of daily living and how those losses for daily living activities would translate over into the workplace environment.
Mm-hmm.
So that would go like in the commentary section of the report. That's all I have to say about that. Do you have anything to add?
No, that's just what I was curious about.
Okay. Okay, so let's talk about rating by analogy and using the four corners of the AMA guides. Some of you have heard of the Alvarez and Guzman line of cases. Even though you're just beginning on your QME career, the Alvarez and Guzman cases are some of the most well-known of the legal cases that are impacting the QME evaluation. So this is the topic heading that deals with those cases. And so let's talk about it. It's very, very interesting. So it says, while the whole person impairment component of any rating must be based on the AMA guides, physicians are not locked into any specific method for evaluating whole person impairment under the AMA guides. This is new. This is new as a result of these Alvarez and Guzman cases. This is what the Alvarez and Guzman cases concluded, that we're not locked in to any particular impairment rating method. We can be creative. We can use our judgment, our experience, our training, our skill when evaluating an injured worker's whole person impairment using the chapter table method, chart, etc., of assessing impairment of the AMA guides that most accurately, keyword, most accurately reflects the injured employee's impairment. So if you're a chiropractor and you're dealing with a spine injury, you might think that, chapter 15 is your home base for your impairment rating for this particular examinee, but it may not be. The most accurate rating might be found in chapter 13. It might be found in chapter 17. Now, typically we would think that chapter 15 is the schedule, is where we would find the scheduled rating, the rating that's provided for under the schedule. The AMA guides, the typical strict impairment found under the scheduled rating. And that's true, but it may not be the most accurate rating. The most accurate rating might be found in some table in chapter 6, believe it or not. And many times it is found in chapter 6, even for spine cases. Chapter 6 is the digestive system chapter, and we sometimes rate spine injuries out of chapter 6, if you can believe that. So to continue on, where a particular impairment is not listed, okay, so this is rating by analogy. Rating by analogy is finding another chart, another chapter, another table, another method in the AMA guides that provides an analogous impairment rating. So what is an analogous impairment rating? An analogous impairment rating is an impairment rating that provides for or describes the same limitations to activities of daily living as the conventional impairment rating. So let me state that differently. An impairment rating is analogous when the limitations, let me get this straight. An impairment rating is analogous when its limitations to activities of daily living are the same or similar to another impairment rating. That's the analogy. The analogy is by analogy to limitations to activities of daily living. So let me give you an example. That's a mouthful, and I wasn't sure I had it clear there for a second. That's a mouthful. So let me give you an example. We'll wrap our head around it. So let's take, for example, a spine injury. Spine injury, many times, what kind of limitations to activities of daily living would you consider a person that has a spine injury to have? They might have difficulty with walking. They might have difficulty with sitting. They might have difficulty with standing. Well, none of those limitations to activities of daily living are described under any of the DRE categories that are described in Chapter 15. But in Chapter 6, there is an impairment rating that describes a limitation to activities of daily living that's similar to what somebody with a back injury might have. A person with a back injury might have limitations with heavy lifting. Makes sense? Makes sense. But that's not described in Chapter 15. But it is described in Chapter 6, where Chapter 6 talks about people who have had a hernia. People who've had a hernia, whether it be inguinal hernia, abdominal hernia, whatever, they have limitations to lifting activities. So if you have an injured worker who was involved in heavy lifting, like say on the loading dock at Walmart, and they suffer a back injury and they can no longer be engaged in heavy lifting, they have work restrictions of no lifting over 15 pounds, that might be an opportunity for you to use an analogous impairment rating out of Chapter 6 by analogizing to hernia. It's an analogy. The person doesn't have a hernia, but they have the same limitations to activities of daily living as a person who has a hernia. Okay. Now here in the the study guide, they talk about the Cannon case. Cannon case. I'm familiar with the Cannon case. Cannon case involved a police officer in the city of Sacramento. Officer Cannon had plantar fasciitis. He received treatment for plantar fasciitis. He mostly recovered from plantar fasciitis. He had a qualified medical evaluation, and he told the qualified medical evaluator that his plantar fasciitis was mostly resolved, except for when he ran. When he ran full out, like in a sprint, he sort of had the memory or the feeling or the kind of the memory of plantar fasciitis. If you ever had plantar fasciitis, you know what I mean. It's not painful, but you like feel it. You have the memory of it, that it was there. That's all he had. He could sprint. He could sprint. And on physical exam, he had no positive physical examination findings. There's no physical exam findings for resolved plantar fasciitis. He had maybe some little tiny tenderness on deep palpation of the medial calcaneal tubercle, right, where the origin of the plantar fascia is. That was it. But because he said that, you know, he felt it on sprinting, the qualified medical evaluator, in the absence of any other impairment rating under the strict application of the guides, he used an analogy to people who have a gait derangement. Now, Officer Cannon did not have any of the criteria for a gait derangement. He didn't have an antalgic limp. He didn't have a shortened stance phase. He didn't have any diagnostic imaging findings of degenerative changes of the ankle, the foot, anywhere. He didn't have any of the criteria of gait derangement. So under the strict application of the AMA guides, he wouldn't qualify for an impairment rating due to gait derangement. But the medical evaluator analogized to gait derangement because people with a gait derangement have limitations with weight-bearing activities. And Officer Cannon had some limitations with weight-bearing activities. They had similar limitations. That's where the analogy is. Do you get it? The analogy is to same or similar limitations with activities of daily living. So for Officer Cannon, qualified for 0% impairment rating under the strict application of the AMA guides, ended up with a 7% whole person impairment by analogy to gay derangement. So the QME used the 4 corners of the AMA guides. He stayed within chapter 17, so he didn't go outside the standard chapter, but we can use any of the charts, tables, or chapters within the entirety of the AMA guides. Okay, so that was a long discussion. So QME should be aware that the permanent disability rating schedule, which is based on the AMA guides, provides rebuttable evidence, rebuttable prima facie evidence. Prima facie means taken as correct. So the AMA guides, the scheduled rating is taken as correct, but you can rebut that by using any chart, any table, any chapter, as long as it's the most accurate. And as long as your opinion for most accurate is a substantial opinion, then it can be accepted. To make an impairment determination in rebuttal of the scheduled rating, the physician is permitted to use the 4 corners of the AMA guides. Okay, so they give an example. They talk about industrial cancer. Now, I'll tell you why industrial cancer is in this section here. It's in this section as a metaphor. Now, I'll share with you what that is. So let's just read it. It says, the guides do not provide direct ratings for cancer. Don't provide direct ratings for cancer as such. Instead, the AMA guides provide ratings for specific impairments that a worker may experience as a result of any injury or illness, including cancer, and from the effects of treatments of such cancer. So, for example, we're going to talk about breast cancer right down here. Breast cancer, unless you're a female of childbearing age, a complete mastectomy, bilateral mastectomy, carries a 0% impairment rating. Bilateral mastectomy carries a 0% impairment rating in non-childbearing age females. Does that seem accurate? It's not accurate, but that's the AMA guide's scheduled rating. Well, so in this section, they're encouraging us then to look at all of the different effects that the cancer has on the whole person and to provide for the impairments for those effects or those impacts. Here it says from the effects of treatment. So it says doctors must evaluate and report all rateable impairments resulting from any illness or injury. This is where you have to get down to work and sometimes, stay with these evaluations until it's all done. You might be tempted to quit on it early and omit some rateable impairments, but we're asking you to stay with it until you provide the most accurate rating, including cancer and or from the effects of treatment of such cancer found through a full and thorough medical evaluation. So, for example, for breast cancer, the medical report should reflect that the QME has conducted a comprehensive medical examination and considered not only the impact from any mastectomy, lumpectomy, or lymph node surgery, but also any impairment resulting from other forms of treatment such as chemotherapy, radiation, long-term medications, like what? Like how about hair loss? To prevent recurrence, the impairment assessment should reflect consideration of the following without limitation. This is just an example for breast cancer, but it's an example of the type of thinking you want to go through in each case. So here they talk about the presence or absence of the breasts, loss of any function of the upper extremities due to the surgery, like if the pectoralis muscle is involved, including range of motion, loss of strength, neurological abnormalities. So this is stuff that would be out of chapter 16, right? Now you're into chapter 16 in a breast cancer case. Skin disfigurement and scarring, now you're in chapter 8. Okay, and there's generous impairment ratings provided for scars, depending on the nature of the scar. Chronic pain, any permanent impairment resulting from chemotherapy treatment, including any onset of premature menopause, right? Sometimes cancer treatment can lead to early menopause. My goodness. Loss of ovarian function, neuropathy, or any other permanent side effects. So, if your sister had a workers' compensation injury that resulted in a bilateral mastectomy, she would want a full consideration of all of these things, right? So we owe this to our injured workers. Also, any permanent impairment resulting from radiation treatment, any permanent impairment resulting from the side effects of these medications, and on and on and on. And the point is, you can see that this is an exhaustive list related to breast cancer. And I'll tell you what's the origin of this. The origin of this, and this is what brings us into the new anti-bias era that we're now in, is that there was a lawsuit in 2015, 2016, I'm going to say. It's called Page versus Perry Soto. George Perry Soto is the executive director of the DIR, Department of Industrial Relations. And so Page was an injured worker, and her and several other hundreds of female injured workers brought a lawsuit against the Department of Industrial Relations for what they described as gender discrimination. And they cited example after example of how women are discriminated against in not only impairment ratings, like for example, breast cancer. A double mastectomy qualifies for 0% whole person impairment rating, because according to the guides, the function of the breast is for lactation. Okay, so if you're not a childbearing age female, the breasts have no function according to the AMA guides. Well, that's not accurate. So they brought a lawsuit against the Division of Workers' Compensation, and now that's what started this whole anti-bias era, because the allegation was gender discrimination and gender bias. And the breast, and Page, I think it was Page, that was a breast cancer sufferer. So Page versus Perry Soto was in part about breast cancer cases being underrated and improperly rated by qualified medical evaluators. So the point of this is twofold, really. It's a metaphor for discrimination, bias, gender discrimination, but it's also a metaphor for how we need to consider the totality of how these impairments impact our injured workers beyond simply just the primary body part involved in the injury. Okay, any questions on that? Okay, all right, let's go on to now apportionment determinations. So back to our PowerPoint. We're here. Talked about industrial breast cancer. Okay, I explained about Page versus Perry Soto. Okay, let's go into apportionment determinations now. So impairment and apportionment determinations only apply when examinees are permanent and stationary. So you don't even need to consider these two sections in your report if your examinee is not permanent and stationary. But when the examinee is permanent and stationary, your opinion on any impairment must include an apportionment determination. And the issue with apportionment is you have to tell us how much of the impairment is due to the industrial injury and how much of that impairment is due to other factors. Because why do we need this information? We need this information because the employer is responsible for the portion of the impairment that's due to the industrial injury. And the employee gets to swallow or eat the portion of the permanent impairment that's not due to the industrial injury, that's due to other factors. And this is new. This whole concept is new. It's new to people like me because I've been at this a long time. It's not new to you. It was part of the workers' compensation reform in 2004, but it's still talked about today, 20 years later, as if it's new. Because before 2004, the existing apportionment laws were in place for over 30 years. So this is still relatively new, and we're still wrapping our head around this whole idea of apportionment in this new era. So in 2004, Arnold Schwarzenegger signed some legislation. The legislation was Senate Bill 899. I remember it like it was yesterday because it was a big deal at the time. It's a big deal. And the whole purpose of the legislation at the time was to address what were referred to at the time as skyrocketing costs. Costs were skyrocketing. And so this legislation attempted to address skyrocketing costs. One of the ways it attempted to address skyrocketing costs was by changing apportionment laws. It used to be, before this reform, that the employer was, in most cases, was responsible for 100% of the cost of the disability. We called it disability in the day. Today we call it impairment and/or disability. In the day, it was simply disability. The employer was responsible for all of it, with very few difficult to obtain exceptions. Can you imagine the cost to employers? So costs were skyrocketing. Well, this new legislation brought in labor codes 4663 and 4664, and you need to know these. You'll be tested up and down on 4663 and 64. It's only two laws. These are our apportionment laws that govern apportionment today. And 4663 was changed by Senate Bill 899. 4664 was brought in brand new with Senate Bill 899. And both of these labor codes attempt to address skyrocketing costs by limiting the employer's liability, by requiring that the employer pay only, and you'd like it this way too, right? Only for the part that you're responsible for. Wouldn't you want that? Wouldn't you want to pay for only what you're responsible for? It makes sense, right? So that's how it attempted to address these costs. So let's go over 4663 and 4664. We'll start here in the physician's guide, the study guide. And I think we'll pull these labor codes up exactly and read them word for word. Pretty sure I have them here. Okay, no, we'll pull them up. Pull them up. Okay, so let's go to the study guide. It says California workers' compensation system requires employers to compensate employees for any disability directly caused by a work injury. It should say for only the disability directly caused by a work injury. But I think it goes on to intimate that here in the next section. It says, but employers are not liable for disability that was caused by other factors occurring either before or after the industrial injury. After the industrial injury, oh my God. You're going to get injured workers, believe it or not, that have had an industrial injury and then at some time later had a car accident injury. That's after the industrial injury. They had a sports injury, a slip and fall injury, an illness, something. They had a bad surgical outcome, something after the industrial injury. So you need to take a good history on before and after the industrial injury, right? And that's described in 4663 and 4664. So this concept of apportionment protects employers from being forced to pay for disability that is not the direct result of an industrial injury. Makes sense, huh? You'd want it the same way. Labor Code Section 4664, which I think they should talk about 4663 before they go into 4664, but they don't. It provides that the employer shall only be liable for the percentage of permanent disability directly caused by the injury, AOE, COE of employment. Therefore, our reports, all QME reports, must include an apportionment determination in order to be considered complete on the issue of permanent disability. So you can give us your impairment rating, and that's all good, but you then must tell us how that impairment rating has to be divvied up amongst the employer and the employee. Otherwise, your impairment opinion is not a complete opinion. We'll have to come back to you for a supplemental report or get a new evaluator or somebody who can give us a complete opinion. Labor Code Section 4663 requires a physician to make an apportionment determination, and here's the language of the law. By finding what approximate percentage of the permanent disability was caused by the direct result of injury, AOE, COE, And what approximate percentage of the permanent disability was caused by other factors, both before and subsequent to the industrial injury, including prior industrial injuries. Now, this is fascinating. Notice this. It says, including prior industrial injuries. Isn't that interesting? It's interesting that it does not say prior sports injuries. It does not say prior auto accident injuries. It does not say prior slip and fall injuries. It's specific for prior industrial injuries. Why do you think that would be? Anybody care to venture a guess?
Because technically they can be aggravations of a pre-existing injury, and then anything else that was industrial is another workers' comp claim.
Correct. And legislators have long known that many injured workers are frequent flyers. They have multiple, people have multiple industrial injuries. And so in passing and enacting this section of the labor code, legislators are asking us to turn our attention to the prior history of industrial injuries. And the employer is not responsible for any disability that's due to the prior industrial injury. They're asking us to specifically investigate a history of prior industrial injuries. It's so interesting to me that they use this specific language. When they could have said here, including anything. We're talking here about other factors. It says other factors both before and subsequent, including, they could have said including obesity. They could have said including arthritis. They could have said including birth defects. They could have said anything. They specifically intended to put in prior industrial injuries so that we would turn our attention to an investigation of prior industrial injuries. See, the intent of passing this law, you always have to ask yourself, what was the legislative intent? The legislative intent was to address skyrocketing costs. This is one way how they address skyrocketing costs, by requiring the employer to be responsible only for the portion that they're responsible for. Okay? Interesting. Okay, so under our new apportionment laws, we have what is newly described as apportionment to causation. This is a brand new topic, brand new concept. It says that although the law requires apportionment of the causation of the worker's permanent disability, for example, it means that what portion of the final disability, if any, was caused, this is causation. What are the causes? By factors other than the work injury. So our job is to tell the parties what are the causes of the impairment or the disability. And for apportionment, we can think of impairment and disability as synonymous terms. Some people disagree with this. I've written much on it, argued much on it. In my opinion, as regards our obligation as QMEs in rendering apportionment opinions, impairment and disability are synonymous terms, okay? So we render opinions on impairment. So then we have to tell the parties what are the causes of the impairment. One of the causes typically will be the work injury. Maybe you'll conclude that the work injury was 0% cause, but typically the work injury is some portion of the cause, but it could be zero. You have to tell us, okay? We rely on you to tell us. We rely on you to tell us how much we owe this injured worker, okay? Because what we don't owe them, they have to eat themselves. A QME report that apportions, okay, no, it says, physicians, however, may not apportion to the causation of the injury. Now, this may be a little hard to wrap your head around. Remember that when we talk about apportionment, we're talking about apportionment of the impairment, not apportionment of the injury. So we want to know what are the causes of the impairment. not what are the causes of the injury. Sometimes factors that cause the injury or contribute to the injury are the same as factors that cause or contribute to the impairment. But many times they're not. Many times they're different. Sometimes they can be the same. And as long as you clearly explain how the cause is contributing or causing impairment, and don't use the phrase causing injury, you'll be okay. Let me see if I can rephrase that a little bit clearer. Sometimes some of the factors that contribute or cause an injury are the same as the factors that cause or contribute an impairment, but not always. Sometimes they are. If you do apportion to some of the factors that cause the injury as the same factors that are causing the impairment, you can do that as long as you explain it. But you have to be clear that you're apportioning to the cause of the impairment. Yeah, I said that better that time. You just have to be clear that you're apportioning to the causes of the impairment versus the causes of the injury. You get it? Any question on that? There must be 10. Is that clear as mud? Maybe we'll just go on. A QME report that apportions causation of the injury rather than of the disability is not substantial evidence. To be substantial evidence, the report must disclose familiarity with the concept of apportionment and describe in detail the exact nature of the apportionable disability. So how you describe the disability or the impairment, we're going to use those terms synonymously, how you describe it can significantly impact your apportionment determination. One description can have its own unique apportionment, where a different description can have a completely different apportionment. It depends on how you describe it. Sometimes you have an impairment that's subject to apportionment where you can describe it completely differently and escape apportionment. It all depends on how you describe it. So you must be very, very clear in your description of the disability, and then you can tackle the idea of apportionment. I know this is difficult to wrap your head around. When you get your first case, give me a call. There are algorithms for handling these types of complex decisions. And it must set forth the basis for the opinion. This is where your reasons and your pertinent facts come into play. That way, the board can determine if you're properly apportioning under the correct legal principles. Okay? So here's an example they use about apportioning the causation of injury. It says, physicians may occasionally make the mistake of apportioning causation of injury rather than causation of permanent disability. This is more likely to occur when an injury is either a cumulative trauma. So with cumulative trauma, you know, the cause of the injury is not really that clear. It's not that clear. Or an event such as a heart attack or stroke, for example, injury that is not the result of a typical workplace accident, or in cases where the distinction between the injury and the disability may be unclear. So how can I explain this better? A good example is found in this case. This worker suffered a shoulder injury at work, underwent surgery for the injury, and suffered a stroke as a result of the surgical complications. The stroke, which was the injury, was clearly industrial because it occurred in the course of treatment for the shoulder injury. In his report, the QME apportioned the pre-existing factors of diabetes and hypertension, which he asserted increased the risk of stroke. Okay, so but diabetes and hypertension are risk factors for the stroke. That is true, correct? It's true. But those are risk factors for the injury. The stroke was the injury. He's right. But what is the impairment? The question is, what is the impairment? Does it say what the impairment was as a result of the stroke? Was it loss of language, loss of ability to drink liquids, loss of use of the right upper extremity? What is it, right? whatever it is, whatever those impairments are, those are due to the injury, not to the causes of the injury, right? They're not due to the hypertension or the diabetes. They're due to the fact that he had a stroke. You get it? This is actually a pretty good example. In his report, the QME apportioned the pre-existing factors of diabetes and hypertension. Those are risk factors for injury, risk factors for stroke, which he asserted increased the risk of stroke. That's true. This was error, though, because the doctor was apportioning to pre-existing health conditions that may have contributed to the injury, but there was no evidence that these pre-existing conditions caused any of the workers' disability. Now, they don't tell us what the disability was. I'm just saying it's, maybe loss of use of a right upper extremity, maybe a gait derangement, stroke, typical stroke deformities and stuff like that, loss of speech, right? Those are the disabilities, which are not in any way due to the diabetes or hypertension. It's due to the stroke. The stroke was the injury. So that's actually a pretty good example. Kind of a difficult, this is an advanced concept for sure. Rather, the permanent disability was entirely the result of the stroke, which was indisputably industrial. Okay, so that makes sense. So the proper apportionment determination in this case probably was that 100% of the disability was due to the injury, the stroke, for which the employer is responsible. 0% was due to other factors. What other factors? There are no other factors. Guy had a stroke. Okay, so here it goes into more detail on risk factors. And this should bring apportionment to a conclusion. Yeah. So it says, as explained above, QMEs may not apportion the causation of the injury, determining that the injury was more likely to happen due to specific factors. Right? This is where, like, obesity comes in, diabetes comes in, being a female comes in. This goes back to the Page versus Perry Soto lawsuit. In Page versus Perry Soto, there was a whole legion of women who had very low permanent disability awards for carpal tunnel syndrome, actual carpal tunnel syndrome. So what happened in those cases was the medical evaluator took away or apportioned away a large portion of the impairment due to carpal tunnel syndrome because the injured workers were women. by thinking or arguing that carpal tunnel syndrome is 6 times more common in postmenopausal women, because these women were postmenopausal, they were 6 times more likely to develop carpal tunnel syndrome. The employer was not responsible for that. See, so being a female is a risk factor for carpal tunnel syndrome, but it may not be a contributing factor to the impairment associated with carpal tunnel syndrome. I think they go over that here in this, so let's go through it. May not apportion the causation of injury, determining that the injury was more likely to happen due to specified factors, such as being female. QMEs may also not apportion to risk factors, including to gender or age-based risk factors. So never use the term age of a person of this age in your report. A factor that may increase the risk of a particular kind of injury or condition is not evidence that the factor actually causes or contributes a portion of the disability. So here's risk for injury. Here's apportionment of the disability. Risk of injury is not the same as cause of disability. Apportionment must be based on actual evidence as to the individual worker, not based on categorical risk factors and assumptions based on those risk factors. There have been accusations in some cases, and here they're talking about Page versus Perry Soto, of discrimination on the basis of age or other factors based on statements in medical reports about age or gender, or other things too, like lifestyle, obesity, genetics, etc., as a risk factor for any particular injury or condition. In other cases, medical evaluators may have referred to gender-based or gender-related risk factors such as menopause or pregnancy, leading to a concern that workers may have suffered a reduction in benefits based on gender. Like, I have an impairment rating due to carpal tunnel syndrome. You're apportioning away most of my benefits because I'm a woman. I can't help it that I'm a woman. This is what they argued in the Page versus Perry Soto lawsuit. Okay, that's gender, and that's gender-based discrimination. And this is really important now because we're entering this so-called anti-bias era. Discrimination within the workers' compensation on the basis of any protected category, including gender, age, race, religion, national origin, is unlawful and impermissible. QME should be alert and sensitive to this issue at all times. And you're going to see an explosion in discussions about bias. I just was at the DWC's conference in Oakland, DWC Educational Conference in Oakland. It was March, early March. No. Well, it was just a couple weeks ago. And there was a discussion on bias, and I consider myself pretty current on topics about bias in the medical legal evaluation, but I learned a whole host of new things that I'd never even heard of. But once I heard of them, I became aware that, yeah, you know, I do these things. I have these biases, these implicit biases and stereotypes. I have them. We all have them. But it's not fair. It's not fair to have our opinions and conclusions colored by our biases and stereotypes. And there's a new push to eliminate that. A worker's permanent disability compensation should never be reduced as a result of discrimination. QMEs are required to provide medical opinions that are fair, impartial, and based on their best medical judgment. Specifically, QMEs are required to treat all injured workers in the same way. That is, to not discriminate or be biased against anyone because of race, sex, national origin, religion, or sexual preference, or because of whether the worker is represented by an attorney or not. Okay, any questions on this so far? We'll just wrap it up. I just read a case. I had a case where a qualified medical evaluator was replaced on the case. It was found that she was had race discrimination, and she was describing her injured worker, and she was in deposition, and she was responding to questions. Okay, yeah, it's coming back to me now. She was in deposition and she was responding to questions, and one of the attorneys was asking her, do you have an independent recollection of Mr. Smith? That's a common question you'll get in deposition. Do you have a recollection of Mr. Smith? And the qualified medical evaluator said, yes, I do. I remember Mr. Smith. He was 47 years old, about 5'9", of Negro blood. She said he was of Negro blood. And I considered him to be under-muscled. This is what she said. She said, I considered him to be under-muscled for a person of Negro blood. This is what she said. So that exposed her stereotype that persons of Negro blood are of a certain somatotype, a certain body type. Do you get that? She considers that persons of Negro blood perhaps are more athletic or more muscular, or I don't know. But she considered him to be relatively under-muscled, was the term she used, for a person of Negro blood. So the attorney jumped on that right away and identified that as race-based discrimination and had her replaced as the qualified medical evaluator. Okay, interesting. All right, so let's finish this up because this is important. So, you know, can you ever apportion in a case of an older person? Can you ever apportion in a case that involves a female injured worker? You can, of course, but not when it's gender-based. It has to be condition-based. So let's talk about it here. It says it's important to recognize the distinction between apportionment to a gender or age-based risk factor which is not permissible, and apportionment to an actual medical condition that a worker may have as established by the medical evidence in a particular case, and that may be an actual cause of a portion of that injured worker's permanent disability. For example, apportionment to age as a risk factor is not permissible, but apportionment to pre-existing arthritis, see, arthritis is an actual medical condition here, actual medical condition, but apportionment to pre-existing arthritis, as evidenced in the medical records, like for example in diagnostic images, is permissible, even though arthritis is an age-related condition. So here you're apportioning to the condition of arthritis. You're not apportioning to age. So you wouldn't say things in your report, you know, persons of this age commonly have arthritis or anything like that, but you can apportion to the condition of the degenerative change of arthritis. Apportionment to gender or menopause as a risk factor or industrial carpal tunnel syndrome is not permissible, but apportionment to actual pre-existing and or non-industrial carpal tunnel syndrome, if and when that's established in the worker's own history, is permissible, even though carpal tunnel syndrome may be more common in postmenopausal women. So a female comes to the job site, she shortly thereafter complains of carpal tunnel syndrome. She has bona fide carpal tunnel syndrome, but the medical evidence indicates that she had pre-existing carpal tunnel syndrome. You can apportion to the pre-existing carpal tunnel syndrome, but you can't apportion to the fact that it's apportioned to the gender. You can't apportion to the fact that she's female. In these cases, apportionment to these pre-existing conditions, even if age or gender related, is not discrimination. It's a medical determination as to the actual cause of the disability. In summary, the question to be answered in any apportionment determination is that question that's set forth in Labor Code Section 4663, and that is, tell us, we're asking you to tell us, what approximate percentage of the permanent disability was caused by the direct result of injury, and what approximate percentage was caused by other factors? This question can only be answered on the actual medical evidence as to each individual worker. Determinations on the wrong issue based on inadequate medical exam or any of the disqualifiers for substantial medical evidence will disqualify the opinion. Finally, notice here that the law allows for the use of approximate percentages. So no one in the world is going to bust you up on your percentages, okay? As long as your opinion is substantial and you provide how and why reasoning based on relevant facts, no one's going to kill you on your percentages because the law allows for approximations. Now, when this first came out in 2004, when I learned of the word approximate, I used to use a range of impairment values. I would say things like, in my opinion, 80 to 90% is due to industrial injury and 10 to 20% is due to other factors. I would use a range. But I quickly learned that even though the law allows for approximate percentages, they want an exact number, okay? So you would say, in my opinion, approximately 65% of the impairment is due to the industrial injury, and approximately 35% is due to other factors. So the law allows and encourages the use of approximate percentages. So you don't have to worry about, you know, the precision and the numeric accuracy of your percentages, although you do have to provide an exact and specific number, but you phrase it as an approximate percentage. And what a relief. What a relief that we don't have to be scientifically exactly certain. We can be approximate. We can be approximate. Okay? So I want to show you an example of an actual apportionment determination. which I have right here. So this is an actual apportionment argument from an actual QME report. I have the report cut off and only the apportionment section of the report remains here. So here's how you'll set up your apportionment argument within the body of your report. So here is the cover letter question from the attorney that relates to apportionment. So this question has been extracted out of the cover letter and has been installed into the template right here. This is the apportionment question to which we are responding in this section of the report. So the attorney says, please include a determination of what percentage of permanent disability, if any, so it says, if any. So which attorney do you think authored this cover letter? This is from the defense attorney, right? The defense attorney's thinking, you know, there's probably none, but if there is any, tell us how much was caused by other factors. See, he doesn't want to know how much is due to the industrial injury. He wants to know how much is due to other factors, because it's the other factors that his client is not responsible for. He wants you to amp up, increase the percentage due to other factors. You can tell that because he gives you a list of things that he wants you to consider here. He says other factors may include, but are not limited to, all these things: pre-existing conditions, disabilities, congenital defects. See, the employer's not responsible for the impairment that's due to congenital defects. So you can see what the attorney's after here. He's after addressing his client's skyrocketing costs. Okay, interesting. And then here's the cover letter question from the applicant attorney. He says, please advise whether you believe there should be apportionment to non-industrial factors. Whether you believe. He's hoping that there's none to non-industrial factors and all of it's due to the industrial injury, in which case his client will receive a greater compensation, okay? So here's how you set it up. You say, my formulation of the apportionment of the permanent impairment follows. So then you detail for us the exact nature of the apportionable disability. You remember that requirement from the Escobedo case? It said we must detail the exact nature. So here it is. You detail it, the exact disability. In this case, my exact disability is 7% whole person impairment due to the specific spine disorder of, and this comes out of table 15-7. Maybe we should put that here, table 15-7. This is exactly described. Oops, I didn't get that. This is exactly described in table 15-7. And then you tell us under 4663 how much, and you do that exactly according to the formula that was given to us. We predicate it on reasonable medical probability here. It says, in my opinion, and within reasonable medical probability, approximately, we use the word approximate, approximately 0% of the permanent impairment is due to the injury. Oh boy, is due to the December 9 industrial injury, and approximately 100% is due to other factors. Now, this isn't going to make us very popular with the applicant attorney, is it? But the defense attorney is going to love it. So what are the other factors? What other factors are there? Well, we tell them. We say, in this case, the other factors include disability caused by the natural progression of pre-existing disease or conditions. Let's see, is that something that he used up here? He used pre-existing conditions, he used disabilities, right? So we give it to him. We said, Mrs. Jones had disability caused by the natural progression of pre-existing disease or conditions. What do you mean? Well, she has a history of pre-existing lumbar spine injury. His condition is expected to progress with time, and absent this substantial pre-existing history, I would have expected he would have a better outcome regarding his recent industrial injury. This isn't a perfect argument. I took this off for one of my clients' reports. This isn't a perfect argument, but he's laying out there the fact that Mrs. Jones came into this with some pre-existing conditions. So this QME does a pretty good job on that. Substantiating reasons for this conclusion, this is what makes your apportionment argument now. This is what really makes it, are your reasons. The reasons. The reasons for this conclusion. What is the conclusion? The conclusion is 100-0. It's 100-0, right? That's the conclusion. And so you predicate it on reasonable medical probability. You provide the pertinent facts, and you tell us the facts upon which I rely include imaging studies show pre-existing conditions. There was a prior industrial injury in 2014. It's all laid out in fact. It's not based on any speculation. In other words, this is how you qualify your opinion and conclusion as substantial medical evidence. It's an exact formula, and it's required. It's required by law. Otherwise, your opinion cannot be used. It doesn't rise to the level of substantial medical evidence. Okay, without delving into all of the particulars of this, are there any questions about apportionment and substantial medical evidence? It's a fascinating subject. We could talk about it for days. So interesting. It's going to be a new way of thinking for you to start qualifying your opinions as substantial opinions. So before we move on, any questions on that? And QMEs find the apportionment section of the reports the most difficult section of the report. It's the section of the report where you have to close the door, put your cell phone away, and you have to get down and engage in some concentration and some complex medical decision making, because it's this section of the report that requires you to really, synthesize a lot of the data and facts about the case to come up with the proper opinion. And I'll just show you this. If you think about all of these criteria to constitute substantial medical evidence, number one is it has to be based on reasonable medical probability. Number two, it has to be based on relevant facts. Number two, it must have how and why reasoning in support of the opinion. Number four, it cannot be based on speculation, surmise, conjecture, or guess. Right? If you think about all of these criteria are really like truth filters. They're truth filters, right? You can pour into the top of the filters like a funnel. You can pour into the top of the funnel all of your apportionment percentages, right? 100-0, 90-10, 80-20, 70-30. You pour them all in the top. Well, only the accurate percentage is going to pop out the bottom of the funnel. Inaccurate percentages are going to get clogged up in the filters, right? The filter of reasonable medical probability. If it's not reasonably medically probable, it's going to get stuck in that filter. If it passes through that filter, the next filter it has to pass through is it has to be passed through the filter of pertinent facts. If there's no pertinent facts to support that number, it's stuck at that filter. If it can pass through that filter and the filter of how and why reasoning, and not based on speculation, surmise, conjecture, if it can pass through those filters and pop out the bottom, it only pops out the bottom because it's true. Not true numbers get clogged in the filters, and you won't be able to write up the apportionment argument. You'll be stuck. You'll be stuck trying to put a round peg in a square hole, and you'll hate your Saturday afternoons because you're trying to provide an opinion that's not true, okay? So when you're on the right numbers, your apportionment argument will be a breeze. It'll be a breeze. It's when you're on the wrong numbers that you'll struggle with your apportionment approximate percentages. Okay, so let's get together on where we are. Finally, this is just the conclusion on apportionment, and then we'll take a break. Apportionment shall be based on causation. Your job is to determine all of the contributing causal factors of the applicant's permanent disability and impairment at the time of the permanent and stationary or maximum medical improvement evaluation. Constitutes substantial medical evidence. Always frame your opinion in terms of reasonable medical probability. Make sure it's based on pertinent facts. And when I review your reports in the future and I look at your apportionment determination, this is where you're going to struggle. You're going to put in facts. You're going to put in what you think are facts that support your opinion. But I'm going to find that they don't support your opinion. What opinion? What opinion are we talking about? We're talking about your opinion on the numbers, 90-10, 80-20. The facts have to support the numbers. And it's a new way of thinking for you. So just keep that in mind. Must be based on an adequate exam and history that must follow the dictates of the AMA guides. Must set forth the reason. Why do you say that? Why do you say that? Why do you say that? Voluminous and compelling reasons with the emphasis on compelling. Compelling, it trumps voluminous, but voluminous and compelling is the winning formula. And it then must not be in any way based on speculation. And if I'm the defense attorney or the applicant attorney and I don't like your opinion, I'm going to allege that your opinion is based on speculation. And they have a whole science as to how they do this. Trust me, they're very, very good at it. And I sometimes get caught with allegations that my opinions are speculative. And they're always good arguments. They're good arguments. And then you have to respond to those arguments. If you can't respond, they win. So it's quite a game. Okay, so let's take a 5-minute break. We'll come back and keep right on going straight through till 2 o'clock. Okay, I'll meet you back in 5 minutes.
Dr. Carpenter? Hello, Dr. Carpenter?
Yes, I hear you.
Oh, good. I came a little late because I couldn't find the link. Will I be able to get access to your slides that you're using?
Sure.
Oh, good. Now, how is it that I'll be able to get them?
I'll send them.
Great. Thanks a lot. It's
Okay.
a
See you
joy
back
to
here.
listen to you. What?
All right. Be back in 5 minutes.
Bye-bye.
Okay, can you hear me?
Yes,
Anybody there?
Yes, I can hear you.
Yes.
I can hear you.
Okay, let's rumble. We got a lot to do, so let's go. Couple questions. What are the requirements to become a qualified medical evaluator? So this has to do with accreditation and reaccreditation. Chapter 1 from the QME study guide. Go ahead and read that. Now, can you imagine some test questions on this particular type of factoid? Can you imagine some questions like this? Okay, must devote at least 1/3 of total practice time to providing direct medical treatment, must pass the competency exam. Who's considered a physician under Labor Code 3209? And that's answer B. MDs, DOs, psychologists, acupuncturists, all these different providers are considered physicians for purposes of QME evaluations. What factors are considered in determining the percentages of permanent disability according to 4660? Remember, there's 3 things that are taken account of. The language of the law says shall take account of. There's 3 things. So those are the nature of the injury, the occupation, and the age of the injured worker at the time of the injury. This, of course, this is our job as the qualified medical evaluator, the nature of the injury. How does Labor Code 4660 utilize the AMA guides in assessing permanent disability? Is it by adopting treatment guidelines? No, the AMA guides don't provide treatment guidelines, right? They're all about evaluation of permanent impairment. But answer B, by using the descriptions and measurements of physical impairments and the corresponding percentages of impairments. That's how 4660 relies on the AMA guides for the purpose of establishing here the percentages of permanent disability. That goes into B there, the factor of B. Okay, finally, what is the principle behind apportionment of permanent disability under LC 4663? Go ahead and read that. Okay. How does 4664 define an employer's liability in the context of permanent disability? Employers liable only for the portion of disability directly caused by the injury. Okay, makes sense. Okay, let's continue. So now we're going to go into the study guide again, which is here, study guide. And we're going to talk about substantive medical disputes resolved by QMEs. This is from Labor Code sections 4060 and 4062. And the fact that this is in the QME study guide tells you that the Division of Workers' Compensation considers these labor codes, you know, to be important labor codes. So we're going to go over these in great detail. And you're going to get a couple aha moments here, and you're going to learn what it is that causes your phone to ring for requests for evaluations. So we're going to talk about 4060 to 4062, and we're going to break them out one by one. And we're going to talk about the different types of evaluations that each one of these labor codes control. So I'll give you a little heads up. when your phone rings for a request for an evaluation, you're going to want to know what's going on with this evaluation. What's the issue? What do I need to do? You're going to want to know. Well, if you can determine which of these labor codes is driving the need for your evaluation, you'll know exactly what you need to do in that evaluation. This is a concept called determine the scope of the evaluation. You're going to want to know what is the scope of the evaluation that you're getting involved with so that you can handle that evaluation quickly and efficiently. And the scope is described in each of these labor codes. So let's go over each of these labor codes. Okay, so it says the sections below describe the general kinds of disputes that QME sees when evaluating injured workers. Okay, so let's go over the first dispute. The first dispute is described in Labor Code section 4060. These involve disputes over the compensability of the claim. So you can see that this issue does not involve a dispute over injury, over body part of the injury, over the presence or absence of injury. Doesn't matter if the person's injured. What they want to know is this claim compensable? It's a dispute over the compensability. Basically, the insurance company doesn't want to pay. The injured worker wants some benefits, and there's a dispute, okay? These disputes are resolved under this labor code, which is Labor Code section 4060. I'm going to get my highlighter here. Okay, so this is 4060. So let's read from 4060. A dispute over compensability is a dispute over whether work caused an injury recognized under workers' compensation laws. The types and kinds of injuries recognized under California law are discussed on pages 9 and 10. So that's your specific and cumulative trauma types of injuries. And you have the physician's guide. The discussion in chapter 3 of the physician's guide is still applicable in certain issues of causation of injury, except for the section on lighting up of pre-existing disabilities. Anyway, I don't know about that. It says the parties use this section. When they're saying this section, they're talking about section 4060. They use this section to resolve disputes over compensability at any time after the claim form is filed. So there's a quiz question. When is 4060 applicable? It's applicable at any time after the claim is filed, but only before the claim for any body part has been accepted by the claims administrator. If it's been accepted, there's no dispute. So 4060 deals with your denied claims. These are denied claims. So when do claims get denied? Claims get denied at the inception of the claim. A claim doesn't get denied at the end of the claim. A claim gets denied before it even gets off the ground at the inception of a claim. So claims have a life cycle. They have a beginning, a middle, and an end. Certain disputes arise at various portions along the life cycle of the claim, and these are disputes. Compensability, this is a dispute that arises at the inception of the claim, right? It's like the claim's on the launching pad. It can't get off the launching pad until it becomes an accepted claim, and there's no longer any dispute that this claim is compensable. Interesting, right? Very interesting. So how can you tell if you're dealing with a compensability dispute? It's a dispute at the inception of the claim. So your first tip-off to a compensability dispute has to do with the date of injury. The date of injury is going to be relatively close to the date of a request for your evaluation, right? If you get an evaluation today, today's March 23rd. If you get a call tomorrow for an appointment and you learn that the date of injury is January 23rd, only 60 days ago, right? That tells you that this dispute is at the inception, at the early stage of this claim, it's probably a denied claim for which they need your determination. Okay, so that's a little heads up when the phone starts ringing in your office. And if you can determine that you're dealing with a compensability dispute versus some other dispute, now you know exactly what you need to do in that particular evaluation. It tells you what you're doing, okay? For example, an injured worker files a claim form for an injury to the back and the foot. If the claims administrator accepts the injury to the back, the parties may not use Labor Code Section 4060 to determine if the foot injury is a work-related injury. Instead, the parties must use Labor Code 4062. So because she accepted the injury to the back, the issue of the foot is not resolved under 4060, it's resolved under 4062. Okay, we'll get to 4062 in just a couple minutes. If the injured worker is not represented, okay, so this talks about how the QME panel process unfolds. Says if the injured worker is not represented, the claims administrator must either tell the worker that they request, meaning they, the claims administrator requests an examination to determine compensability, or the other option is the claims administrator sends the worker a notice that the claim is denied and the injured worker now may request a QME for this purpose. Now, the injured worker gets the first bite of the apple. The injured worker gets the first opportunity to request the panel. The injured worker gets the first opportunity to request the specialty of the doctor to do the evaluation also. In either case, the injured worker has a right to request an evaluation, and the injured worker always has the first right to submit the panel request form and to specify the specialty of the QME panel. Okay, so that's 4060. 4060, the compensability dispute. You're going to see a flood of these, okay? Because so many claims are being filed. Okay, listen to this carefully. Imagine you're a claims administrator. Okay, you're managing 300 to 500 files of claims yourself, right? And you're getting calls of 3 to 5 to 10 new claims per day, okay, for claims for industrial injuries. You have to have a system that allows you to quickly decide whether to accept or to deny a claim. You have to have a system. And the system basically devolves down to whether or not the injured worker can prove the injury. The injured worker has the burden of proof of proving industrial injury. So the claims administrator very quickly looks at the facts of the case and asks him or herself a question. They ask themselves, can this injured worker prove the injury? If the answer is probably not, no, then very quickly the claims administrator gets out the denied stamp and just denies the claim, denies liability for the claim, and becomes a denied claim. So you're going to get a ton of denied claims. It's going to form, 60% of all your volume as a qualified medical evaluator. And the tip-off to the denied claim has to do with the date of injury. It's going to be a relatively recent date of injury. If you get a call tomorrow for a date of injury 2021, that tells you that the dispute is coming, at the end of the life cycle of the claim, different than the compensability dispute. Okay, so that's 4060. Now, 4061 deals with a whole different set of issues. You need to know the issues. Before you go to the evaluation, you need to know the issue. So you want to get yourself a copy of the form that tells you which labor code is driving the need for the evaluation. And I'll show you those in just a minute. An evaluation under 4061 is invoked by the injured worker or the claims administrator objecting to a determination of the primary treating physician about only a couple of issues. Number one, the existence and extent of permanent disability, that's one. right? Primary treating physician says, you're not disabled. The injured worker says, I object. Primary treating physician says, this person's a 70% disabled. And the claims administrator says, I object. So that's existence and extent of permanent disability. Or whether the injured worker is in need of future medical care. So only 2 disputes are driven under 4061. You need to know those. It's permanent disability and or the need for future medical care. Those are only 2 issues that are resolved under this labor code. The trigger for the permanent disability dispute is the termination of temporary disability, generally caused by a medical report of the primary treating physician that finds the injured worker to be permanent and stationary or has reached maximum medical improvement. Okay, this is not the only trigger, but it's a trigger, and they're talking about it here in this example. There are other triggers as well. So, like the compensability examination, the procedure for obtaining a panel of QMEs depends on whether the injured worker is represented or is not represented by an attorney. If the evaluator declares the injured worker permanent and stationary for the body part evaluated, and the evaluator finds that the injury has caused permanent partial disability, the evaluator shall complete a return to work voucher and serve it on the claims administrator. Okay, so this is just a side issue. I don't even know why they put it in here. It's more of like an administrative type of requirement. If you declare the injured worker permanent and stationary, and you're the first evaluator, okay, between you or the primary treating physician, if you're the first evaluator to declare this person permanent and stationary, then you're required to fill out this form, DWC-AD form, that tells us what is this employer's return to work situation. Do they have restrictions? Do they have no restrictions? Okay, you're required to do it. It's a pain in the butt, but it's a requirement. Okay, for some reason they stick that in this section of this discussion. Okay, so let's summarize. 4060 deals with what kind of disputes? Deals with compensability disputes. 4061 deals with what kind of disputes? Deals with permanent disability and or the need for future medical care. Okay, so there's between the two of them, it's only 3 types of disputes. And then for each, depending upon whether the injured worker is represented or not, they have different pathways to getting a QME panel. Okay. 4062 is resolves all other disputes. All other disputes. It says resolves disputes not covered by 4060 and 4061. So this is the catch-all. This is the catch-all category. Anything not related to disability, compensability, permanent disability, or future medical care is resolved under 4062. Like what? Like, how about work restrictions? Primary treating physician says the injured worker needs all these work restrictions, can't lift, can't bend, can't stoop, sedentary work only, and claims administrator says, I object. I want to have this case evaluated by a QME. So all other disputes not covered under these sections. So this is a catch-all for any dispute that is not compensability or permanent disability with the need for future medical care. Because starting January 13 for new injuries, and as of July 1st, 2013 for all injuries, disputes over any current need for medical treatment are no longer among the disputes resolved by QMEs. We talked about that. These types of disputes are now resolved by IMR. Okay, they're no longer resolved by QMEs. Yeah, these disputes instead are resolved through IMR and on and on. Okay, so it's a catch-all. 4062 contains explicit time frames. Do you think you might be required to know the time frames? Of course. In which objections to medical determinations of the treating physician must be made. In represented cases, either party may object to a medical determination by the treating physician by notifying the other party in writing within 20 days, within 20 days. Why do you think there are timelines? There are timelines to help keep this thing moving along and to avoid delay. In represented cases, or within 30 days of receipt of the treating physician's report in unrepresented cases. The timeframes to object may be extended by the agreement of the parties. Okay, and here's some examples of some of the different types of disputes. Temporary disability, work restrictions, new and further disability, new body parts. You're going to get new body parts all the time. New body parts. So the original injury was to the lower back. 6 months later, it's ballooned to include the lower back, the right shoulder, and the temporal mandibular joint. Okay. Whether or not there's any compensable consequence, injuries, new and further, and all these, all other disputes not covered under 4060 and 4061. Okay, so let me show you. Let me show you this form. I think I have these forms. I have a PDF here. Yeah, here's QME form 105. So this is the form. This is called QME form 105. This is the form that an unrepresented employee uses to request a qualified medical evaluator panel. Now, this is interesting. It's interesting because this is filled out by an injured worker. Injured workers are lay people. They don't know a lot. They don't know much. So here where it asks them to tell the reason that they're requesting a QME panel, you'll notice that all of the reasons are written in words. They're written in words because injured workers don't know about labor codes and codes of regulation. So here they have the words. So the first opportunity for them to check is to determine if the injury is work related. Attach a claims administrator's notice that the claim was denied. So this is the denied claim. This is the compensability evaluation under 4060 right here. But they don't put 4060 because injured workers don't know what 4060 is. They put here the words. The next one is 4061, that there's an objection to the primary treating physician's determination regarding TD, PD, or the need for future medical care. That's 4061. 4062 is anything else, dispute over additional body parts, whatever, or other, and the injured worker can write in here what it is that they think is the nature of the dispute. So that's form 105 for unrepresented injured workers. Let's take a look at QME form 106. So 106 is an online only form. This is filled out by the parties. Okay, this is not filled out by injured workers. This is usually filled out by attorneys. And what I want to show you is that, it's a completely different kind of form, especially here where the reason for the evaluation here is described by the labor code. For the unrepresented injured worker, they used words. But here for attorneys that know the system, claims administrators that know the system, see, this is for represented injured workers here. They can just simply click the code and tell the nature of the dispute. It auto-populates with the dispute. So 4061, it populates with the dispute. Here's your only two options, you see. 4062, it auto-populates with the various different types of disputes. And the party will indicate, what is the dispute. So for you as the qualified medical evaluator, you want to get a copy of QME form 106 when you schedule the evaluation. Now, you're not going to be able to get it in every single case, but if you can get it, then it tells you exactly what's the dispute. If you can learn the dispute, and they don't always tell you the dispute. Sometimes they tell you nothing. Sometimes you don't even get a cover letter. You don't get any medical records. You get nothing. But if you can figure it out through obtaining this form, then you not only know exactly what you need to do in that evaluation, but even more importantly, you know what you can omit, what you can skip, what you don't need to do, right? You don't need to assess compensability. You don't need to assess compensability if you're dealing with a dispute under 4061. That's not the issue. So if you can get this form, it'll help you greatly in knowing what to do and where to go in your evaluation. Okay, so that's 4060, 4061, and 4062. Let's see what else I can tell you about that. Okay, I showed you forms 105 and 106. Let's move on. So just a couple words about the compensability dispute, and this is very, very fascinating. As I said, the claims administrator has to have a system for very quickly determining whether to accept or to deny cases, right? And what they do is they rely on the burden of proof. The claims administrator knows that the burden of proof rests on the party holding the affirmative of the issue. This is described in Labor Code 5705. So in this case, for a compensability dispute, the affirmative of the issue is held by the injured worker. It's the injured worker that's forwarding the issue that they've been hurt on the job. Okay, it's not the claims administrator that's forwarding an issue that, no, you weren't hurt on the job. The injured worker has the burden of proof of establishing industrial injury. Okay, so the claims administrator looks at the facts of the case. Imagine you're a claims administrator and you have the facts of the case, and the facts of the case suggest an unwitnessed incident, unwitnessed, for an injury for which there was a delay in reporting, right? The worker's coming forward on Monday and saying that, last Friday when he was on the loading dock, he hurt himself. So unwitnessed incident, a delay in reporting the injury. Claims administrator looks at that and says, the injured worker can't prove it. They can't prove it. It's going to be difficult to prove it. Denied. They get out the denied stamp and they just deny it. It's a system. Okay. And it's based on the burden of proof. And there are other instances and crossroads that we have to deal with in our work that we do that deal with burdens of proof. That's a topic for another discussion. Apportionment is one of them. That's a topic for another discussion. So 32025 says all parties and lien claimants shall meet the evidentiary burden of proof on all issues, and they have to do it by a preponderance of the evidence in order that all parties are considered equal before the law. Now, what is the preponderance of evidence? Preponderance of evidence means that evidence which, when weighed with evidence opposed to it, has more convincing force and the greater probability of truth. When weighing the evidence, the test is not the relative number of witnesses or facts, it's not the number, but the relative compelling and convincing force of the evidence. That's why I said compelling trumps quantity or voluminous. Compelling trumps voluminous. So this is fascinating. Imagine this: an injured worker has a denied claim and he's faced with the burden of proving the claim. Can you imagine how difficult that is for an injured worker? What are they going to do? What can they do? They're lay people. They don't know anything, right? Many of them are, non-English speakers. What are they going to do? How are they going to prove their injury? They have to prove it by the evidentiary burden of proof. How are they going to do that? Well, one of the evidences that they use to help prove their claim is your report. Your report forms part of the evidence that they're going to use, that they're going to present, that will help them prove their case. So they come to us in the hopes of gaining evidence that will support their claim for injury. This is the compensability determination that you're going to be called upon to do in approximately 60% of the cases that you evaluate. So it's important to understand like what's operative behind the scenes that brings this case to you for the evaluation. Okay, 4061, 4062. So all of these disputes, these are the three disputes, the substantive disputes that are resolved by QMEs. Oops, wrong highlighter there. These are the two pathways through which QME panels are issued. So there's two pathways depending upon whether the injured worker is unrepresented or whether the injured worker is represented. So let's take a look at both of these pathways to the QME evaluation. Those should be found here. Go to 4062.1. Okay, 4062.1 says if the employee is not represented by an attorney, so you need to remember this. 4062.1 deals with unrepresented injured workers. A goes to B. 4062.1 goes to unrepresented. The employer, which is the same as the claims administrator, shall not seek agreement with the employee on an agreed medical evaluator, nor shall an agreed medical evaluator prepare the medical evaluation on any issues in dispute. Why do you think this provision is written into the language of the law? Somebody, anybody? Anybody? Dr.
it's kind of-
Sollenberger?
I was just gonna say the employee doesn't really know much about the process. It'd be kind of coerced, probably.
Correct. Exactly. What does the employee know about doctors that do workers' comp evaluations? They don't know anything. But the claims administrator sure knows a bunch of doctors. Okay, so that would be exercising an unfair advantage on an injured worker. If either party requests a medical evaluation pursuant to 40, 60, 61, or 62, either party may submit the form, that's QME form 105 for unrepresented. You got that? 105 for unrepresented. I showed you that form. Either party may submit the form requesting the medical director to assign a panel of 3 QMEs in accordance with 139.2. We went over parts of 139.2. However, the employer may not submit the form unless the employee has not submitted the form within 10 days. Here's a timeline. Here's a timeline. Within 10 days after the employer has furnished the form to the employee and requested the employee to submit the form. So the claims administrator learns of this dispute. Claims administrator denies the claim, sends the injured worker a denial letter and says, if you want to pursue this, here, go ahead and request a QME appointment. Here's the form. And the claims administrator waits and waits, and she's got a calendar. She's got a calendar system on her software. And when the 10th day comes up, if the injured worker hasn't taken the initiative to request the panel, then a couple of things have happened. Either the injured worker has dropped off and dropped the matter, or is being irresponsible or whatever, and the claims administrator then takes the initiative to do the scheduling him or herself, okay? Says, but the claims administrator has to give the injured worker 10 days to get their act together to request the appointment, request the panel. The party submitting their request form shall designate the specialty of the physician that will be assigned to the panel. And based on this description here, the injured worker has the first opportunity, right? Injured worker has the first opportunity. Within 10 days of the issuance of the panel now, here's another timeline. So now as many as 20 days could go by, right? Right? So within 10 days of the issuance of the panel, okay, so here somebody's already submitted the form. The panel's now been issued. Within 10 days of the issuance of the panel, the employee shall select a physician from the panel to prepare the medical evaluation. The employee shall schedule the appointment. So you're going to get a call from unrepresented injured workers. They're going to call you because they're following through on their requirement. And the employee shall inform the employer of the selection and the appointment. So right here, the injured worker calls your office, you give them a day, date, and time for the appointment, a day, date, and time. They are then obligated to call the claims administrator and say, here's my day, date, and time. I followed through. I did what I'm supposed to do. Okay. And that satisfies their requirement and secures them the appointment that they wanted with you, that they chose, the specialty that they chose. This is how they get what they want. They have to comply with these requirements. But some employees are irresponsible and lazy. So if the employee does not inform the employer of the selection within 10 days of the assignment of a panel, then the employer may select the physician from the panel to prepare the medical evaluation. Okay, so they have a 3-doctor panel. Either the injured worker or the claims administrator can pick whoever they want off of the panel. If the employee informs the employer of the selection within 10 days, but has not made the appointment, or if the employer selects the physician, then the employer shall arrange the appointment. And we get calls sometimes from the claims administrator. I always like it when we get calls from the claims administrator, because when you get a call from the claims administrator, that tells you that she plans on paying for that appointment. Okay. It's a good sign. Upon receipt of written notice of the appointment, arrangements from the employee, or upon giving the employee notice of an appointment arranged by the employer, the employer shall furnish payment of travel expense. Okay, so that's that. Okay, and then this talks about our obligation at the face-to-face evaluation. I don't know why it's in this section of the law, but now they're jumping days. Okay, so from B to C, they jump 10 days. And then another 10 days of the issuance of the panel. Now they're jumping to D, which could be, 90 days later. It says at the evaluation, the evaluator, which is you, shall give the employee at the appointment a brief opportunity to ask questions concerning the evaluation process, all that stuff. You guys develop rapport and talk with each other and get rapport going. Always know that the employee can discontinue the evaluation. And we'll talk about that in just a couple minutes. Always know that the employee can discontinue your evaluation. And you need to inform the employee in advance of beginning the face-to-face evaluation that they can discontinue the evaluation. It's not described here in this section of the law, but it's described in another section, CCR 40, which we're going to talk about in a few minutes. But always know that the injured worker can discontinue the evaluation if they have good cause. Basically, if they feel that you're discriminatory or have a bad attitude, they don't have to put up with that and they can get out of there. Okay? So that's 4062.1 for unrepresented. Let's go to 4062 for represented. Now, a little bit different process because we got some other parties involved. We have applicant attorney involved. We got defense attorney involved. It says no earlier designate. Let's skip this section. It says within 10 days of the assignment of the panel. So the panel has now been issued. Okay. Each party may strike one name from the panel. So the applicant attorney strikes a name, defense attorney strikes a name, the third doctor who's unstricken gets the job, okay? The remaining QME shall serve as the medical evaluator. Now pay close attention to this. It says, if a party fails to exercise the right to strike a name from the panel within 10 days of assignment of the panel, then the other party may select any physician who remains on the panel to serve as a medical evaluator. So imagine you're the applicant attorney. You got the panel. Okay, you requested a panel. The panel's now here. Yay, I got the panel. It's here. You look at the three names of the doctors on the panel and you look at one that you don't like and you strike that name in the hopes that either one of the remaining two doctors will be one doctor who will be favorable to your client. Okay. So time starts ticking and you're waiting and you're counting the days. And on the 10th day, you haven't heard from the defense attorney. The defense attorney has not issued her strike. Woo-hoo-hoo! You now, by law, get to take the remaining two doctors on the panel, or even I think it says any doctor on the panel. It says any doctor. It says the other party may select any physician, okay, who remains. So you've already stricken one. There's two that remain. Okay, so you can choose either of the two that remain. Because the defense attorney blew the timeline. They blew the 10-day timeline. And each side is hoping that the other party blows the timeline. That way they have the opportunity to choose the doctor they want to choose, right? So this is a big game right here. You're going to be dealing with this all the time when you get these phone calls. You're going to want to know, have both parties stricken, right? A high quality appointment is an appointment where both parties have exercised their right to strike and they both agree that you, Dr. Sollenberger, you are the last doctor remaining on the panel. You get the job. When you get a panel where one party has exercised two strikes, the other party hasn't exercised a strike, what do you think the chances of that other party coming up with some sort of a disclaimer such as, we never got the panel. We're just learning of this case now, right? Can you foresee that could happen? Of course, it happens all the time. So you wanna qualify your appointments when they come in. The represented employee usually means the applicant attorney. So the applicant attorney takes over this obligation. The represented employee shall be responsible for arranging the appointment for the examination. But upon his or her failure to inform the employer of the appointment within 10 days, here's another timeline. There's a lot of 10 days. After the medical evaluator has been selected, the employer then may arrange the appointment and notify the employee of the arrangements. Okay, and then the employee shall not unreasonably refuse to participate in the evaluation. The parties may agree to an AME at any time. And sometimes they will. You know, you'll go through the whole admin of setting this thing up, right? Hours of staff time. And you'll get a call, 2 weeks before your evaluation. We're going to use an AME. And you drive your fist right through your computer monitor. It's just part of the deal because they can agree to an AME at any time, except as to issues that are subject to IMR. Okay, even AMEs don't resolve medical treatment disputes. And a panel shall not be requested pursuant to subdivision B on any issue that has been agreed to be submitted to or has been submitted to an AME unless the agreement. So that's not often going to happen, or at least you won't be aware of it when it does happen. So that's 4061 and 4062. They both deal with the same issue. They deal with the pathway to the QME appointment or the issuance of a QME panel. They just deal with different people. 4062.1 deals with unrepresented injured workers, where 4062.2 deals with represented injured workers, and the represented side has a lot more timelines. So should be aware of these timelines. Okay, so any questions on that? The QME, that's referred to as the QME panel process. And it's important to be aware of it because this is all happening behind the scenes. And these are the sequences of events that cause your phone to ring for appointments. So it's important to understand, you know, what's driving the need for these appointments. Some quick questions, and then we're going to get on to the next. 4060 applies to disputes over compensability, but does not apply where the employer accepts part or all of the bodily injury as compensable. Okay. Any part that the claims administrator does not agree to, that would be evaluated under 4062, as we said, the catch-all labor code. Under 4062, if either party objects to a medical determination made by the treating physician concerning medical issues not covered by 4061 or 4060 employees represented, what is the next step? The next step. Well, you have to resolve that dispute by obtaining a medical evaluation in 4062.2 for represented injured workers. An employee is represented. So you have to be able to pick out of these questions, you know, these little nuances like is represented, is not represented. The fact that this one refers to is represented points here to 4062.2. You see how you have to pull that out of the question and make that connection here. So that's how a lot of the questions on the competency exam are going to be. They're not going to be direct, you know, memorization type questions. They're going to be questions that require you to do some analysis. One more set. What is prohibited if an employee is not represented by an attorney, according to 4062.1? Well, it's prohibited that the employer seeks an agreement with an AME. It's prohibited. That's an unfair advantage. What happens if either party requests a medical evaluation according to 4062.1b? Either party, this is the one that deals with 10 days, either party may submit a reform to the medical director. That's QME form 105. Remember that? But the employer may only submit the form if the employee has not done so within 10 days after being furnished with it. Okay. Okay, let's go on to the next section because I have lots I want to go over with you, and we have a speaker coming to join us. We'll learn of him shortly. Let's get into now section 6, and I'm going to pull out some of the highlights from section 6. So in section 6, again, we're in the study guide. Here's section 6. It talks about the examination process, scheduling and cancellation, information, ex parte communications, lots of different stuff, conflicts of interest, examination disclosures, a lot of stuff. Now, we don't have time to go over all of this stuff, but this is the subject matter of today's discussion. So you're going to be responsible for going over this yourself. It's a lot, but it's not a lot. It only encompasses, 10 pages. Okay. So I'm going to pull out of here a couple of things of particular interest to us, and you'll be responsible for the remainder. So let's go back to our PowerPoint, and I'm going to pick and choose. Let's talk about examination disclosures and ethical requirements. See what we have here. Real quick on face-to-face time. I guess we'll talk about that real quick. It talks here in the study guide here about face-to-face time. This is described on page 30. So there are some requirements for face-to-face time. Here's the requirements for neuromusculoskeletal evaluations. This is real simple. You can make it real simple. For neuromusculoskeletal evaluations, the minimum face-to-face time is 20 minutes. For psych evaluations, minimum face-to-face time is 60 minutes. Okay. All others, pulmonary, respiratory, cardiology, etc., is 30 minutes. So you can remember that very easily with this diagram here. 20, 30, 60. Okay? Okay, let's talk about examination disclosures under CCR 40. See what the study guide has to say about CCR 40. Those are under the examination disclosures right here. So let's go to page 27. Okay, examination disclosures. So we talked about this a little bit briefly before. It says a QME at the time of the evaluation. So when is the time of the evaluation? Is that a form that you sent to the injured worker 2 weeks before the evaluation? No, it's at the time of the evaluation. That's what it says. You shall advise an injured worker before the examination or at the time of the actual evaluation of the following items. So this means that you're in the examination room with the injured worker, face to face, you're getting ready to start, and this is part of your introductory procedures with the injured worker, is to advise them of their rights. Their rights are described in CCR 40, QME Regulation 40. They have rights at the evaluation. The evaluation is all about them, okay? They have rights. And you're required to tell them what are their rights. So here are some of their rights. Number one, Mrs. Jones, if you have any questions at any time about anything, you just ask me, okay? You can ask me any question that you want, and I will answer that question to the best of my ability. Now, I might not know everything. If I don't know it, I'll tell you. If I do know, I'll tell you. But if you have any questions, you let me know, okay? And you get a head nod from them, okay? You follow that? You let them know that they can discontinue the evaluation if they're not comfortable here. Mrs. Jones, if you're not comfortable here for any reason, if you feel that I'm abusive, I'm rude, I'm hostile, if you feel that I have an attitude about injured workers, if at any time you're not comfortable here, you don't have to put up with that and you can leave. Okay, do you understand that? And you get a head nod from them. This is required. And very, very few qualified medical evaluators do this process. And the Division of Workers' Compensation is cracking down on this process because it's a process that's designed to enhance the experience for the injured worker. It's all about the injured worker. And this is what guarantees that the injured worker will have a positive experience during their interaction with you and that they won't be subject to your bad attitude, okay? So you go through this with them in advance. As much as it is for them, it's also as much for you because it helps set your tone and helps set your attitude prior to beginning the face-to-face evaluation. You have to let them know that, Mrs. Jones, you will not be required to undergo any kind of unnecessary exam procedure. And this is often important for female examinees to be reassured that, you know, they're not going to have to disrobe or, you know, be exposed or anything like that. Now, if you have to do something that's required, Mrs. Jones, your evaluation involves the lower back. I will be required to take a look at your lower back. I may ask you to raise your shirt. I may ask you to pull your pants down to your hips. Are you okay with that? And you get a head nod from them so that they can feel comfortable. When required as a condition of probation, either by the administrative director of the Division of Workers' Comp or as required by your licensing authority, whether it be California Medical Board, chiropractic examiners, the QME shall disclose his or her probationary status. So probations happen, probations come and probations go, and sometimes, unfortunately, if you're on a probation, you have to disclose it to the examinee, and you're entitled to explain the circumstances around the probation. If you're found to be on probation and you didn't disclose it, it's a problem. So better to disclose it than to not disclose it. If at that time the injured worker declines to proceed with the evaluation, such termination shall be considered by the administrative director to have occurred for good cause. So the injured worker can make a decision as to whether or not to proceed with you or whether or not they want to get a new evaluator. So, if you have some sort of a probation, like, my last report was 20 days late, and the injured worker might say, that's no big deal. Just get mine in on time. But if you said, I'm on probation for sexual misconduct hearing, the injured worker might decide that, that's not something they're comfortable with, but they have the opportunity to decide. If the injured worker declines to ask any questions relating to the evaluation procedure and does not otherwise object on the grounds of good cause to the exam proceedings, when it says during the exam itself, the injured worker shall have no right to object to the medical legal evaluation based on a violation of this section. How is this relevant? What is this gibberish? What does it have to do with anything? What it has to do with is injured workers who get your report, don't like your report, and then complain about your report. What it says is, if they finish the exam, if they don't complain during the exam itself, they will have no right to object to the evaluation later after they got your report and you said something that they didn't like. So this one helps protect us. Your goal is to get the examinee through a completed appointment, okay, with no objection. That's the goal. If you can get them through a completed appointment with no objection, then they'll have no right to object later on. And you have to explain this to them in advance, okay? They need to be aware of this in advance. And I explained it to them just like that. Mrs. Jones, if you don't have any objection to the evaluation during the evaluation itself, you can't then complain later. So if there's something you're not comfortable with here, declare it during the exam and we'll terminate the evaluation and we'll both move forward. And that's it. And they always give you a head nod, and they never terminate the exam. I had one single exam terminated in my entire career. Guy said to me, he didn't like the line of questioning as we got started on the evaluation. He didn't like the line of questioning, and he said, he gave me this, and he said, you said I could terminate the evaluation. I'm terminating the evaluation. And then I wrote my brief report. I did get paid because he showed. We started. I went there. I wrote my report and I said, we started the questioning and he became uncomfortable and he exercised his option under CCR 40 and he left. I have no idea what happened. I thought I might get him back, but he obviously got another evaluator that probably had a different approach than me. So it's not a big deal as long as you advise them in advance and as long as you're not, as long as they don't have good cause, like you're abusive and rude. If the injured worker terminates the exam process based on an alleged violation of section 40, I think this is probably what happened to my guy. I hope so anyway. And the appeals board later determines that good cause did not exist for the termination. See, I didn't think my examinee had good cause. I was just asking him questions about what happened with the injury, what's going on. You got a denied claim, so the parties want to know what happened. So tell me what happened. I need to explain it to him. So tell me what happened. And he said, I don't like this. So If they determine that good cause did not exist, the cost of the evaluation shall be deducted from an injured worker's award. Well, big deal. What does that mean if it's a compensability evaluation? There is no award yet. So anyway, so that's the disclosure requirements. So how do you do this? I'll show you how we do it, and I'll show you how we do it. What we do is we hand the injured worker a form. And as far as I know, I invented this procedure because I presented this procedure to the administrative director more than a decade ago. And she's long gone. She died. And she approved this procedure. And so this is how we do it. So we hand them this written form. The top form deals with ex parte communications. And we haven't discussed that, but it's in your materials. It's under 4062.3. So they read the top half, and then they get into the bottom half, which is Regulation 40. And you can see it's laid out exactly the way I just showed it to you, except for a typo right there. It's laid out, and they read it. And it's exactly the language from CCR 40. And so once they're done reading it, of course, they never understand it, because it's way over their head with section 41G, and they don't know what all this stuff means. So then we go over it line by line by line, just the way that I showed you. And I say, Mrs. Jones, if you have any questions at any time, you let me know. If you're not comfortable here at any time, you can leave. You won't have to go through any unnecessary exam procedure. Do I have your authority to examine your lower back? Okay, and you just go through this line item by line item. Mrs. Jones, if I was on probation, thank goodness I'm not on any probation, but I would be required to tell you, but thank goodness I'm not. Finally, Mrs. Jones, if you have any questions or any problem, declare it during the examination, because if you leave the examination, like if you get my report and you don't like something I said in the report, you can't complain about me then at the time. You're going to complain, do it during the evaluation so that everybody's on the same page on it. And you get a head nod from them. They hand you back the page. And guess what? From there on, through the conclusion of your evaluation, you and the examinee are bonded, because the examinee knows that you're not going to be rude and she can relax. The examinee knows that you're not going to be abusive, and you've already reminded yourself to not be abusive, and you now have rapport, and you can proceed with an effective evaluation where both parties can contribute. Okay, it's a fabulous procedure. Whoever invented this is a genius, because it works like a charm. You know, I've only had one person ever discontinue the evaluation. Every other single one went through to its full completion, which is what you want. Okay, that's CCR 40. Let's go to the next one, which is the ethical requirements under CCR 41. So again, back to the study guide. Any questions on the disclosure requirements? Okay, very few. The most, you know, if a QME tells you that they do the disclosure requirements and you ask them, how do you do it? Most QMEs, if they say that they do it, they will tell you that they do it by way of sending this document or a document to the examinee in advance of the appointment. They send it to them in the mail. But I'm suggesting that it be done in the face-to-face evaluation, because the actual language of the law, it says at the time of the actual evaluation. That's the language of it. Okay. So that's CCR 40. Let's go to 41. Those are here's the ethical obligations. Okay, so this is interesting as well. And there's some areas here where you could be caught off guard and out of compliance with this particular regulation. So it says the ethical obligations of QMEs are worth noting and are set forth in this section, section 41. And they cover a variety of issues, including but not limited to office cleanliness, appointment scheduling and report content, and a bunch of other things as well. We'll go over some of those. If the injured worker terminates the examination based on an alleged violation of, for example, ex parte contact regulation, the QME disclosure requirements, Rule 40, failure to maintain a clean and professional office, other things, conflict of interest, etc., and the appeals board later determines that good cause did not exist, again, the cost of the evaluation shall be deducted. So this again provides the injured worker opportunity to terminate the evaluation. Like, why? Like, this office is a dump, right? The injured worker can terminate the appointment on the office and the conditions of the office. Now, there's another section in this regulation that talks about the appropriateness of the office and the office containing all of the necessary tools and instruments that are required for the evaluation. And I, one time in my career, was in violation. I now realize I was in violation of this regulation. And the violation had to do with me as a chiropractor conducting my evaluations in a podiatry office. I rented space in a podiatry office. And in the podiatry office, they have different type of examination tables than we as chiropractors have. They have tables that are perfect for podiatry examinations, but not so well suited to a chiropractic spinal or extremity examination. And so I would, lay my examinees down on this podiatry table, and I realized that, this is not a proper table. And if the examinee ever complained that, why are we doing this evaluation on a podiatry table? And it wasn't actually a proper office, and it was actually a violation of this particular ethical obligation. Okay, so let's continue. It says, an evaluator is not required to undertake or continue. So this is the part of the ethical obligations that protect us as the evaluator. It says an evaluator is not required to undertake or continue any evaluation where the injured worker or his or her representative uses abusive language towards the evaluator or the evaluator's staff. I've never had that. I never had that. Aggressive language, maybe. Assertive language, maybe. Not abusive language. I've never had that. But we are protected if that circumstance should present itself. Most injured workers that I've encountered are very docile and passive because they find themselves a bit like fish out of water in these evaluations. So they're usually a bit passive. But we are protected if we have an aggressive or abusive examinee. Or deliberately attempts to disrupt the operation of the evaluator's office in any way. How can you imagine that an injured worker could disrupt the office operation? How about by being late? By being late, being more than 30 minutes late, and we don't have to meet with them. Or where the injured worker is intoxicated or under the influence of any medication, which impairs the injured worker's ability to participate in the evaluation process. I've never had that. I'm sure there are circumstances where injured workers could be under the influence of medications, but I've never encountered that. If that happens, the evaluator must state under penalty of perjury the facts that support the termination of the evaluation process. And if your facts are accurate and substantive, then you'll be let off the hook. So let's take a look at CCR 40 and the exact language of it in the QME regulations. And you have this document. I sent you this document, and notice that the document has a navigation pane over here. You activate the navigation pane through the View tab. Click Navigation pane. Without the navigation pane, it's a lot less easy to navigate around. So you activate the navigation pane through the View tab here. So here we're on ethical requirements, CCR 41. So it says, number one, you must maintain a clean professional office at all times, which shall contain functioning medical instruments and equipment appropriate to conducting the evaluation within the physician's scope of practice. So I was out of compliance with this by being in a podiatry office. And a functioning business office phone with the phone number so that the people can get in touch with you on the day of the evaluation. Shall schedule all appointments for evaluations without regard to whether a worker is represented or unrepresented. The QME shall not refuse to schedule an appointment with an injured worker solely because the worker is not represented by an attorney. And you might wonder, what's the difference between represented and unrepresented? So we prefer represented injured workers. It's more interesting, it's funner, and the administration on it is sometimes a lot less complex. It's the represented injured workers that have a complexity of administration. So sometimes offices tend to discourage unrepresented injured workers, but that's just disallowed by this provision of this regulation. You shall not request the employee to submit to an unnecessary exam or procedure. So don't do it, and be conscious of it as you're navigating around the exam room and instructing the examinee. Shall refrain from treating or soliciting to provide medical treatment, supplies, or medical devices to the injured worker. And you might get requests from the injured worker. Hey doc, could you be my treating doctor? You know, if you've been with them for 2 hours and you've developed rapport and they're convinced that you're a kind and caring doctor, they may ask you to be their treatment provider, but that's prohibited under this regulation. Shall at all times communicate with the injured worker in a respectful, courteous, and professional manner. And that makes sense, correct? That makes sense. Shall refrain from unilaterally rescheduling a panel QME examination more than 2 times in the same case. Certainly, if you had extra good cause, I'm sure you could write that up and the parties would provide you some leniency on that. It's probably a better situation to move forward with the panel QME, even though it has to be rescheduled once or twice, than going through the whole process of obtaining a new panel and all of that stuff. So, but the regulations is specific for more than 2 times. Shall refrain from canceling a QME examination less than 6 business days from the date the exam is scheduled without good cause, and without providing a new examination date within 30 calendar days of the date of the cancellation. So what did we say were some of the factors that constituted good cause? Anybody? What qualifies as good cause for purposes of canceling for a late cancel? Now, mind you, by the time we get to 6 business days from the date of the appointment, this injured worker has been through 10 days of requesting the panel, 10 days of receiving the panel, scheduling the appointment with you within 90 days by law, okay, 90, 10, 10, they're at 110 days. What would then be good cause for you to cancel this appointment within 6 days after the injured worker has waited and waited and waited for some decision regarding their issue? What could constitute good cause? It has to be good. So what are the things that constitute good cause? Do you remember? Medical. Go ahead.
Family. I would say death in the family, medical emergencies, any catastrophe in the region.
Correct. Natural disaster. And you have to provide documentation of it. So I just had
California is easier, just get an earthquake.
Say it again.
In California, it's easier. Just get an earthquake.
Something like that. Something like that. And usually you have, like for a medical emergency or death in the family, you have to provide documentation, right? Otherwise, it's just your story, right? And I just had a doctor who was coming up on his 30th day. His report was due on the 30th day. And he wanted to know, can we request an extension for getting the report out? And there's very specific requirements for requesting an extension. And I had to tell him, no, you have to pull an all-nighter and get this report out because you don't qualify. You don't have good cause. Do you have a medical emergency? No. Is there a death in your family? No. We don't have a natural disaster that we can fall back on. So no, you don't qualify for an extension.
Mm-hmm.
Same thing goes for late cancellations. Has to be supported by good cause, quote unquote, good cause. Other things from the ethical requirements has to deal with ethics, shall not engage in ex parte communication. There's a whole section in this in the QME regulations regarding ex parte communication. Basically, with ex parte communication is you as the evaluator cannot have discussions with any of the parties, with the exception of non-substantive issues. Non-substantive issues, like what's a non-substantive issue? Non-substantive issue is we scheduled the appointment on March 29th. That's a non-substantive issue. We've not received the medical records. That's a non-substantive issue. You cannot discuss the merits of the case, the details of the case, the facts of the case with any party. All parties need to be kept in the loop with communications. When you communicate outside of the parties, that's called ex parte. Ex parte means outside of the parties. Finally, this is an interesting one. It says all QMEs, regardless of whether the injured worker is represented by an attorney, shall, with respect to his or her comprehensive evaluation, shall review all medical and non-medical records. So who should review the records? It says all QMEs. The QME must review the records, must review all the medical records and or facts necessary for an accurate and objective assessment of the contested medical issues in an injured worker's case before generating a written report. Does it say before the face-to-face evaluation? Doesn't say that. So many times QMEs object to moving forward with a face-to-face evaluation on the basis that they have not yet received the medical records, but that's not a basis for not moving forward. We can see injured workers without the medical records, but the medical records must be reviewed before we generate the written report. That is, unless you generate the written report before the records arrive. Do you follow? Okay. If the medical records come and you've not yet generated the written report, then you're obligated to review those records. But if you've already generated and issued the report and the records come, then you cannot review them before the report. So you just submit the report. And you can deal with those medical records after, perhaps in a supplemental report. So thus the importance of getting your report out quickly, especially in those cases when you've not yet received medical records. Can you imagine getting, 2 weeks after the face-to-face evaluation, your report is, all the way down to the final section, you're in apportionment and work status and this thing's almost done. And then in comes a box of medical records, right? Now you're obligated to process those things. So you should then strive to get your reports out as soon after the face-to-face evaluation as possible. I urge you to strive at least to get the report out in the same business week as the face-to-face evaluation. The super duper top QMEs get their QME reports out on the same day as the evaluation. The low performers get theirs out on the 3rd week, 24th, 29th day. Those are low performing QMEs. Those are QMEs that are complying with the minimum standards. I want to encourage you to exceed all of those standards and certainly get your report out in the same business week. Okay? Last point, and then we'll turn it over to a couple of questions. It says that the report must list and summarize all medical and non-medical records reviewed as part of the evaluation. Now, this is interesting. It describes two verbs in this sentence. The first verb is list, and the second verb is summarize. So how would you imagine that this would appear in the body of your report? You must first contain a list of all the records, non-medical and medical, that you received. And I encourage you to create a chronologically ordered list in chronologic date sequence order, the way things unfolded in real time, right? So it reads like a book in chronology. So you list all of the records that you received in chronological order, and then you summarize each of them. Now, your summary can be more or less brief, depending upon the relevance of those records to your evaluation. The relevance to your evaluation. Those records may or may not be relevant to your evaluation. If they're not relevant, your summary can be very brief, okay? But the language of the law is that the report must list and summarize all medical and non-medical records reviewed as part of the evaluation. Okay, so those are the ethical obligations under CCR 40. Now, in section 6, there's a lot of material in here that we have not discussed, and I'm going to pick up on this material in our next session, session 2. People that attend session 2, we're going to pick right up where we left off and keep right on going. For those of you that are only attending session 1, you're going to need to be familiar with this on your own. So you're responsible for this on your own. And section 6 is quite a large section. It's a lot of codes of regulation in here. These are basically the QME regulations here in section 6. This deals with all of the QME regulations. And here are some of them. They're all listed out here for you. And you can find those in your handout on the QME regulations. It's all of this section over here. 40, 46, all of these from here, appointment notice of cancellation from 34 all the way up to 49 or 48 ethical guidelines. That's all contained in section 6. Okay, so let me stop my screen share. Come back and join you here. And want to open it up for questions and discussions. Does anybody have any questions, concerns, considerations, or comments? And you can all unmute and join the group. Ask all to unmute. Okay, any special circumstances or considerations that anybody wants to run by me?
Is there any advantages recording the examination?
Your examination with the injured worker?
Correct.
I haven't found any. Can you think of any?
I was thinking about if the injured worker then comes alleging a violation of his rights and we have everything on tape.
I don't know of any particular regulation that governs that. I think there is a regulation that allows the injured worker to record the proceedings as long as they notify you. And I think as long as you notify them, you can do that. I've never had a reason, or I've never had an occasion where I felt that I wished I had recorded the meeting. The disclosure requirements work great in that regard because they establish the tone. And I've written on this and conducted programs on this. There's a process called establish the tone of the evaluation. I have a video on YouTube. You might want to watch that. Establish the tone. When you properly establish the tone of the evaluation at the beginning of the evaluation, you never have any problem. It just never comes up. And part of that process of establishing the tone is for you to get your head in the right place before you start the evaluation with the injured worker. So I guess the answer to your question is I don't know if I've never found any need to do it, but I think the regulation allows for you to do it as long as you notify them in advance.
Thank you.
Questions?
In regards to game plan for continued study for the QME exam, I mean, do you think there needs to be a lot of emphasis put on the labor codes and things of that nature?
Yes, and on the QME regulations as well, especially. So here, if you look at this document, I'm not sharing my screen. Let me do it. Let me see, share my screen. Okay, here you go. If you go to the QME regulations, you should all be seeing this. Very easy to go through here and just pick off the major ideas of the QME regulations. You're not going to be required to know these by number. You're going to be required to know them by concept, okay? No one's going to ask you, you know, what is the text of CCR 35.5? I don't even remember those. I have to look them up myself, but I know the ideas. I know the ideas behind them. So yeah, you're going to be responsible for the QME regulations for sure. And then of all the labor codes and codes of regulation that are important, most of them have been laid out for us in the QME study guide. So the Division of Workers' Compensation, in putting together this document, right? This is the DWC's study guide. They're telling us here, they're broadcasting to us what they consider to be the most important of the labor codes. And they list them right here. 139.2, 4060. So we went through all of these for the very reason that these are the most important of the most important. Other ones you're going to encounter, you know, infrequently, and you certainly don't need to know the names and the numbers of them. With the possible exception, I would think, of 4663 and 4664, the apportionment labor codes. Okay, so are you satisfied with that, Dr. Miller?
Yes, thank you.
Does that answer your question on that? Okay, other questions?
Yes, thank you.
Dr. Carpenter, you know, as when we are evaluating impairments, we use the AMA guides according to the timeline. So that is on PNS only. It's not connected with the date of injury, correct?
Rephrase that.
When the person is PNS after 2005, we use the AMA guides, the four corners.
Yes.
And that is strictly on PNS when the person was made PNS. Does it depend on when the date of injury was, in case it was prior to 2005 and the person was made PNS post 2005?
Yeah, it has to do when they're declared to be PNS. So they could have a date of injury in 2004, but they're declared PNS in 2005. Then that evaluation is governed by the AMA guides.
Okay, thank you.
But you know what? You're not going to encounter any evaluations with dates of injury before 2005. I say that almost, 100%. You may. I can't remember when I last had or encountered a pre-2005 date of injury. I mean, we're in 2024 now. So that would be a 19 years old date of injury. And these claims can drag out. They can drag out a decade. They really can. But
I think mainly for the purpose of the test. I agree. We hardly will find a case, but sometimes it's something for the questions or for the test purposes.
Yeah, if they've not been declared permanent and stationary before 2005, then they would be evaluated under the old system. If their permanent stationary date was after 2005, then they'd be evaluated under the AMA guides.
Thank you.
Okay, well, I was expecting Dr. Xavier to join us. It doesn't appear that he's in the waiting room. He's going to share with us his experiences, both failing and passing the QME competency exam. And Dr. Xavier is an educator. He's a professor at the Southern California University of Health Sciences. He's a medical doctor in his country of Puerto Rico and a chiropractor here in the United States. He's an educator. And so, nobody knows better than him about test-taking techniques and how to prepare for examinations, and how examinations are even constructed. And it was interesting because he failed the first examination, even with his vast experience. He failed it. And so he was quite humbled by that. And so as a result of that, he and I collaborated, and it's more his brainchild than mine, but we collaborated on our online exam module. And many of you have had access to our online exam module where we have our test question banks and our exam simulations. So he was going to give us a demonstration as to how that works, but he's not here with us. So those of you that are with us on our next session, I'll make sure that he joins us at that time. And how many in this group are using the online question bank so far?
I think I am. If not, I'd like to
I've
be.
used it.
Who's used it?
Dr. Padieri.
Can you say a few words about it?
It's very helpful, and I actually took 2 of those today in the morning, and I took your pre-test, and from there to the next couple of tests, I think I've improved my score a little bit. So I'm thinking practice, and then I went back to your question banks where you said like revise this section. So I kind of went over that and then took the test at the next section. So I think that was very, very helpful. My question to you would be on the main test, is it more that we need to know the content and how it works and everything, or are they trying to actually trick you, is like getting very close to the answers like how regular boards do? Would that be something we would be seeing on the test? Or?
No, they're not. They're not trying to trick you.
Okay, thank you.
In fact, they want you to succeed.
Okay.
They want you to succeed because we desperately need more qualified medical evaluators. So you might not know this because you all are prospective QMEs, but the QME system is short of QMEs. We have a shortage of QMEs. And some specialties of QMEs are badly underserved. So we need more QMEs. So they want you to succeed. They want you to get your QME credential. They want you to begin doing QME evaluations. Now, they do want you to understand the basics of the system. And it's they've established a very low threshold, in my opinion. And you can tell that they have a low threshold by the requirements that are in place now to sit for the examination. Non-chiropractic providers have no requirement. They have no requirement to sit for the exam. Now, before they get issued their QME credential, they do have to complete a 12-hour course, but even that's a low threshold. So the threshold to sit for the exam is very, very low because the system is trying to encourage more people to become qualified medical evaluators. We need more. So they're not going to trick you, but they do want you to be able to work with the ideas and the concepts. And you know, it's very interesting because when you become a qualified medical evaluator, that's exactly what you have to do. You have to learn to work with these ideas and the concepts, because guess what? Nobody ever tells you the facts you need to know to do a successful evaluation. You have to ascertain them yourself. You have to look at the date of injury. You have to look if there's multiple employers. You have to look and see if this qualifies as a presumptive injury. You have to look and see if there's perhaps a prior permanent disability award that will affect apportionment. You have to work with these ideas and concepts in order to be a successful and a surviving QME. So that's what they're looking for. I'm not going to quiz you on the exact labor codes, stuff like that, but they want to test your understanding of how you can work with the ideas contained within the labor code. So as you go through the material, you know, you might ask yourself, how might this show up on the competency exam? What kind of permutations are they going to put these timelines through in an effort to see if I understand the importance of these timelines? So it's that kind of thing. And these questions are constantly recycled. They're constantly evaluated for their effectiveness. Poor questions are discarded. Good questions are retained. So you're coming in at the latest evolution of the exam, and you're all going to do very, very well. The whole purpose of this review session is to make you an expert on the very few topics that are going to comprise the large portion of the questions that you'll be tested on. And so I think we've accomplished that in this session.
Perfect. Thank you.
Okay.
I had one more question. Would we have any case analysis? Like, would they give you some scenario and be like, okay, what do you think will happen on the test itself?
Yeah, you're going to be given case examples and specific contexts. You know, you're going to get
Okay.
you're going to get questions like, a 38-year-old secretary suffers a repetitive strain injury on September 3rd, 2013. You know, stuff
Got it.
like that.
Yeah.
And you have to go, okay, so 2013, that's an important piece of data, right?
Right.
Right?
Okay.
Or I'll say 2012, and you go, okay, so 2012. If it's a medical treatment dispute, that's not resolved by QMEs. It's resolved by QMEs before 2013, but after 2013, it's not. So you know, you're going to look at timelines, you're going to look at dates, and you're going to ask yourself, you know, what are they trying to get at here?
Got it. Thank you.
Okay, so I look forward to seeing all of you back on our next session next Saturday, same time, 8 a.m., the 30th of March. If between now and next Saturday you have any question or concern, just hit me up by way of an email and I'll respond right away. If there's nothing further today, I'll let you all go.
Thank you
Thank
very
you.
much, Dr. Carpenter.
Okay.
Thank you.
Best of luck.
You take
Thank you.
care. Thanks. Bye-bye.
Thank you.
Bye-bye.
Thank you very much.